Thank you to the Community Center for having us. It's a central location for many of you. Yeah, I'm going to call Lucia. Did I get that right? Here and come on up here. You can come here. I'll get to you in 1 second. She's from the city of Hollywood. She's going to tell you about, I don't know, a whole bunch of great things, I think. Right? And what you're doing here. How many of you live in the city of Hollywood? Perfect. She doesn't take complaints today. No complaints. Okay. So welcome. My name is Gary Pyatt from Campbell Property Management. We're very happy to have you here this morning. This is a CE class. So for those of you, I know we're going around and making sure we have everybody's information, but just a reminder, and you'll probably be reminded several times today, anybody who's taking the class today for CE credits, you'll all get a certificate. But anybody who needs the CE credits, just double check. Make sure that we have you on the list with Josh who's going around. Because this is, as far as your license, if you are licensed, this does qualify for one of your CE credits. So today, what do we have going on today? We do have a course, right? We will have, in a minute, the TC come up and tell you some stuff about Hollywood. Right after that, we have Dan Turin coming up from Campbell Property Management. He's going to give you some board members. How many of you are board members? Probably 99% of you. He's going to give you some best practices. How many of you know everything and anything about being a board member? Him putting up his hand was almost like everybody stepped, you know, when you say who wants to volunteer and everybody steps backward and the guy who didn't move because he wasn't listening is the guy that gets elected? Okay. All right. So you're going to hear some things about board member best practices. These are really good things, especially at this time of the year, because what are we in right now? We're in election time. How many of you have elections going on? Okay. How many of you have budgets going on? How many of you have approved your budget so far? Those are my best friends. Why? Because January 1st, if you're on a calendar year, starts the new collection, right? And if you haven't done it, coupons, So congratulations to those of you that have gotten your budgets approved. And then, our guest, and we're very, very thankful. I know many of these people over my last 20 years in the business. We have Eisinger, Brown, Lewis, Frankel, Shyatt, their law office of Eisinger. They're here today to provide the course. And for that course, we have Alessandra Stivelman. She's in the back, right? We have Carolina Shear. She's in the back. They're all going to be teaching, so you need to be nice to them. Okay? And we have Gregory Eisinger, right, in the back there. And we have my friend from the firm who I've known for many, many years, who sits on my board at the Chamber, and partner, Andy Lewis from Eisinger Brown Lewis. So thank you for coming, Andy. Many of you know Andy that are here involved in the Chamber. And then, at the end, I'm going to come back, and I'm going to do a little bit of a wrap-up for you, some key points. More importantly, I'm going to remind you once again. Okay, I'll do it now, and then I'm going to remind you. And that is, on your table, under your papers, you have this. You have this flyer. As board members, you can never, ever, ever, in my opinion, get enough information. Everybody circulates information. On the second page of this, you'll turn this over and it says Florida Association News, or otherwise what we call at Campbell Fan. Okay? This is a blog, this is a report, this is information. This is information we produce and send to you. You can just see all of this as a flyer. Everything that's there. So I encourage you to go online where it says on that page, Florida Association News is the online resource for thousands of board members. All right? And we literally have board members, okay, that may or may not be affiliated with us or we do business, because this is a great tool for you. I encourage you, go online, get all of the information possible, because you're in these high-paying jobs you have, and notice I got near the microphone. These high-paying jobs you have as board members, you can never get enough information. Agreed? Cool. Yes. So check that out. I will remind you again at the end, and also on your table are these, I will remind you, questionnaires. Why are these important? And they don't have your name on them. Because what is important to us, and I hope you agree with this, what's important to us as we continue to do educational programs, right, for board members, for managers and stuff, that we teach topics and stuff that you like, that are interested in you, that are appropriate, that are going to bring you value, because you're all giving up the next couple of hours here. right? So the more value we can bring to you and things like that are great. So I do ask you, before you run out at the end, okay, just take 2 minutes, even if it's during the class, fill them out, put them in the center, and I'll remind those that are here at the end so I can collect those. Because your information and what you think that we can bring to you is the most important. Cool? Everybody agree?
Yes.
All right, let's get started. Let me bring up Leticia from the City of Hollywood. She's going to give you some stuff, some information about the city and welcome you. And then Dan Tiernan will come up and give you the board member best practices. Anytime you have any questions during or after the program, I'll be in the back. Just please come up and see me. Okay? Cool? Let's get started.
Actually sounds so interesting. I want to become a board member myself. I'll let you do that. I'll talk to you later. So welcome. Thank you for being here. Thank you for having me. Am I speaking? Okay, fine. So my name is Florencio. I actually represent the Office of Communications, Marketing, and Economic Development for the City of Hollywood. Our office supports new and existing business in the community through project management, site selection, market research and data, business connections, and also regulatory permitting for the city. We also have paid close attention to the key commercial corridors such as A1A, Federal Highway 441, and our city's namesake, Hollywood Boulevard as well. There are so many exciting things coming up for the new year. There are new programs that you will become aware as they are launched. A couple, the ones that are highlighted, they are already going on. One is the Commercial Improvement Property, or called CIPIT for short. And for designated areas, is an incentive for property owners to improve the facade of the buildings, commercial, industrial, and it's already been going since 2017, but it's expanded here this year. We are very proud to have several applications already for the program. The new partnership that the city is promoting is for the program of e-permit one-stop program. And it just basically is a process of a short review of certain permits that don't need to be in the whole queue of many others that take so long to. So we're trying to improve the permitting process and become a fast, new, modern city on those terms. What else I would like to say? We invite you also to be informed by everything that the city is doing. If you haven't done so, we have a service called Notify Me. You can sign up through the city's website, and you get notifications about events, classes, meetings, and even traffic updates, if you will. It's called Notify Me on the website. Very simple. Through email, you get notifications. What else? If anybody have questions for me, I could stay longer. I have my card. Any of those programs we can discuss a little further. It also can go online. Everything's being updated. But for today, that's all I have, and I'm looking forward to serve you the new year.
Is that clear?
Good morning, everybody. Again, my name is Dan Turin. I'm one of the owners of Campbell Property Management. My role is I'm the Chief Operating Officer. So my job at Campbell is to make sure that all of our managers that support our 400 communities and 130 plus managers, that they all have the right people, all the right tools to do their job, which is really the right people, the processes, and technology. What I want to talk about today is, what the attorney's going to talk about is what you can and can't do legally and what your responsibilities are. So what I'm going to talk about is a little bit different. Ours is going to be more about how you can be efficient and effective, but still make sure you're doing everything legal. And the area that I'm going to really zero in on is actually board meetings. There's a lot of things you guys are responsible for, but the reason I want to focus on board meetings is that that's really the most visible thing that you do as a board member, and it gives, makes a big impression on your homeowners. Like, if you can run a good board meeting, they have a little more confidence in you. If your board meeting is not well done, it can cause you to lose some confidence in your members. So that's what we're going to focus on today, is making sure that we explain kind of some keys to that. So before we get started, quick show of hands, just try to get a sense of people's experience level here. How many people here have at least 1 year of experience on a board? Okay, then keep your hand up if you have at least 5. All right, we got some good experience. How about 10? We got.
He gets the prize.
He gets the prize. All right. So this is the one person that's been doing this for 10 years. So I'm going to give him a gavel.
Oh, wow.
So any time during the meeting I say something that doesn't make sense, he just says, "Wait a minute, I've got a point." All right. Because if he's done this for 10 years.
All right.
Oh, she did? Who did? Who else had? Oh, okay. Ashley or Diego, can you bring me another one for her? She can use the gavel as well. So we have 2 people we can rely on that will be my assistants for today. All right, so the first thing that we always like to talk about before we get going into this is, well, what defines a good board meeting and what defines a bad board meeting? I think it's actually kind of easier to think about a bad one first. So anyone have any ideas, suggestions? What's a bad board meeting like? Off topic, that's a good point. Anything else? Yeah.
Everybody talking at the same time?
Everybody talking at the same time, off topic. Anything else? Arguing.
One person doing the whole meeting, and the other board members speak up.
None of the other board members speaking up, just kind of being run by one person. So, don't follow the agenda, exactly. But I end up kind of saying the worst board meetings are ones that take too long, nothing gets done, and everybody leaves unhappy. So we're going to shoot for trying to do the opposite of that, right? So what we're going to shoot for is good board meetings, which means they're short, you get a lot of things accomplished, and I'd love to say everyone leaves happy, but I'm a realist, so let's say most people leave reasonably satisfied, okay? So one other quick survey, how many of you would say that your board meetings last, a typical board meeting, not when you have a special assessment or material change or anything complicated, but a normal board meeting would last less than an hour or less? Okay, that's great. How many people would say theirs lasts between an hour and 2 hours typically? All right, we get a little work there for improvement. How about more than 2 hours typically? All right, there we go. So there's a couple people in that have 2 hours or more. Again, absolutely there's instances where you might have to have a 2-hour board meeting because maybe it's the first one of the season or there's a major project or you're knocking your clubhouse down and rebuilding a new one. So there's reasons to have those, but in general, what's that? Oh, well, yeah, this is a board meeting though. Yeah. A members meeting, those can take 3 to 4 hours just because of the logistics of counting the votes and how big you are and so on. But our goal is to kind of give you a template for how to have a board meeting that should be able to last in less than an hour, okay? So the way we do this, because I have an engineering degree, so everything has to have a formula. So 9 key steps to having an effective board meeting. And so I'd love to tell you that I was smart enough to be able to bring these things down from a mountain and share them with everyone, and if they came to me with an epiphany, but I didn't, I cheated. What I did was we have 131 licensed CAMs in Campbell that have collectively over 1,000 years of experience, and we have them get together all the time and meet, and we talk about different things with them, update them on the law and so on, and we'll also ask them to get in the round tables like you're in, and we'll ask them these questions. For example, what makes an effective board meeting? So this is one of the questions I asked them 5 years ago, and we sat down, and they all came up and they presented their ideas, and we curiously wrote it all down, recorded it, and that's how we came up with this. So it's basically the kind of collective knowledge of all of our managers that we pulled together. And one other thing here is Gary had mentioned Florida Association. Can you hear me all right? I wander away, but I talk really loud, so usually it works okay. So Gary had mentioned this Florida Association news, and this is one of the things we do is we put blog posts out all the time. And this was a blog post from a few years ago that it's 9 steps to an effective board meeting. And again, it's under a category called manager's wisdom. Anything that's manager's wisdom is basically stuff where I cheated and got all of our managers to help me figure out the answers and things we should write out. So if you don't need to take copious notes today, because you can always go to FAN and you can see what the 9 steps are. I made them small font so that you'd have to listen to me for the rest of the time. So, but they're on here and you can go look at it later on and follow up if you like. Again, Florida Association news, this is kind of what it looks like when you get on it. It's real straightforward. You know, there's search tools in it so you can find. We've been doing it for 10 years, so there's thousands of pieces of content on there. And it's just all about running your condo, running your HOA, issues you might run into, new technologies, new project processes, etc. A lot of good stuff on there. Okay, so let's get to the steps. So the first one is like, you know, good old-fashioned Boy Scout, Girl Scout thing. It's just be prepared. You know, only include items on your agenda that you're really ready to act on. You know, understand the issue so you can articulate your position. The board meeting is not really a time for brainstorming. And I know some people that are particularly newer on the board get a little conflicted with this. They're like, wait a minute, how do we gain a consensus on this? Because we can't all meet, we'll get a quorum. How do we work through that? And honestly, the way to do it is just with individual conversations and phone calls. And you can do that and not have a quorum. And you can have those kind of discussions to kind of banter things around and email each other and so on. You can't vote online. I shouldn't say what you can and can't do. Those guys will tell you what you can and can't do. But what you generally want to do is have some discussions ahead of time and kind of gain a consensus so that when you get in there, I've actually had some managers that will tell you that they want it to almost be, you know, that you can write your meeting minutes before you even get in there. Because you know what the motions are going to be. You just have to write down how it's going to vote out. It should be that well planned. And one other key thing that I think some people miss on, how many of you feel like you generally get a good board package 3 to 5 days before the meeting happens? A board package from your manager that shows you, you know, bids and information and, you know, okay, not a lot of people. So you really should be getting that. It should include your financial reports, you know, key things on projects that you're doing, background behind it.
From the property manager.
What's that?
No,
From the property manager, yeah, absolutely. Yeah, so if you're not getting that, you should be talking to your property manager about, you know, because the last thing you want to have happen is you show up at a board meeting and say, okay, we're going to make a decision on which contractor we're going to have to redo the piping and the so-and-so, and then here's a bunch of bids. You can't, that's crazy. You need to have seen all that stuff in advance, had a summary analysis of it, been able to review it, and even talked about it before you get in there. So that's the most important thing, is just being prepared. And then the next thing is to make sure that you've got everything set up effectively and that you have the right equipment to be able to do the job. So just real quick survey here. Anyone, what's kind of the ideal setup for how the board members should be relative to the audience? Should they be yeah?
We always had a dais, a flat, straight, rectangular dais.
Right.
And now, because I've been in the furniture industry, we angle it in a V, so people have more contact, board members seeing each other. And we took all the chairs in the audience and put them at a 45-degree angle, so it's not looking across the aisle at people kind of face.
Diego, we need another panel now. So we got it. That was good. Exactly right. I mean, what you want, ideally, if you had an unlimited budget, you would have a horse shape, right? And you'd have it so that it's a reminder of when you sit with a straight line out to everybody, what does that project? That projects that you're talking to them. And you're really not. They're there to be able to listen and observe, but what you're there to do is talk amongst each other, right? So having a horseshoe or a V is the incredibly much cheaper version of that to be able to do that, but that's the whole point of it, is making sure you've got that set up. It really sets the tone for the meeting. So that's one really basic thing. And then from an equipment standpoint, making sure that if you've got something complex, you have access to a projector. Or if you don't, I mean, I'll bring it to our management company. Borrow one from your management company or someone that's coming in. Maybe you don't have a huge community that doesn't have an AV system, but occasionally you'll need to have an AV system. And AV systems used to be really really expensive now. So there's a really cheap way to do this now. You know what it is? What's the cheapest AV system you can get? Does anyone know? A portable one. I have 4 teenagers, so I know this. It's a karaoke box. So you can buy a karaoke box from Amazon. They're really loud. I could actually show you one. I think I have one in my car. It's about this big, and they cost about $100, and they have a microphone, and afterwards you can have a party if you want. But you literally can just speak on it, and it projects really well. So you don't need thousands of dollars of AV systems, and again, it's something to have that might help out. How many of you have snowbirds that are sometimes having to call into meetings, into board meetings? Maybe a third of you. So do you guys all have speakerphones to be able to do that? So, here's another. I like technology stuff again. I'm an engineer. So this is an example of something else you could use. So it used to be that back when I used to work with a large corporation, everyone had those really expensive $600 Polycom center phones that you would have to use. This thing's called a Jabra, and you can buy it on Amazon for $80, and it connects to your cell phone via Bluetooth, and it's basically a cheaper version of that. So again, if you're having, because what I've seen other people do is take their cell phone, turn it up, and put it on there, and then they're periodically saying, what did they say? Or, what did you say again? And it's not good. This does an amazing job. It's a really simple thing. What's that? Jabra, J-A-B-R-A.
Does that plug into like a phone system?
It Bluetooths to your phone.
No, we have like an office phone, and people call into that, and then they listen on the speakerphone of the office phone, but it's horrible.
Okay.
So would that plug into an office phone?
I would probably use free conference. How many people use freeconferencecall.com? Does anybody know about that?
We have something down the way.
Yeah, so there's literally freeconferencecall.com. It's been around forever. You can set up free conference calls. So what I would do is instead of using your office phone and calling into that, I'd set up a freeconferencecall.com. You dial into your phone on that, you connect the phone to this, and now you've got a speaker system. So again, if nothing else, I might save you $50 or $100 in doing something simple. But having simple little things like this are really helpful.
If I may, how is that for hearing people in the audience from the person who called in?
Yeah,
That seems to be the issue.
Yeah, so that you might need to become a little closer. It's almost as good as a Polycom, right? It's pretty good. So you have to walk up to the karaoke box and take the yes. Are you supposed to record meetings? You can if you want to. I mean, some people do because they think it makes it easier to take minutes. But I highly recommend. I would suggest you don't ever want to record meetings, and they'll talk about that later on. They'll say why you don't want all the details of this stuff, because everything that you say could become a liability in the future. It's kind of a shame, but it's the way it is. And one other simple thing is which a really effective tool. In lieu of screaming, what else can you use is those gavels, right? So if you don't have a gavel, it's a really nice, simple little tool. It's amazing. There's still a universal respect in general for the gavel. If you just tap it a couple times, it tends to work. So that's another piece of equipment that's nice to have.
Much better than smacking your hand out on the table.
Exactly. It's much better than smacking your, or telling Sony shut the head, run up or up. So that's much more effective. So next thing is try to establish some time limits. You don't necessarily even need them on the agenda, but I know when I get asked to prepare an agenda, I'll literally be going through saying, listen, we can only spend about 5 minutes on this, 10 minutes on this, and so on. So the point of that is, as you're drafting your agenda, think about how much time it's going to take, because you're going to try to stay under an hour. And if you realize, look, oh, this topic's going to be 20 minutes because we have to replace all the door locks or something, and it's like, wait a minute, if it's going to take 20 minutes of discussion, are we really ready for it or not? Maybe you're not really ready for it, because if it's going to take that long, maybe you should defer it off to the next meeting. So that's the key point about establishing time limits. You just have a real sense of how long each topic should take. And then there's a couple of other things that you can do. Has anybody been in a situation where, does anyone have a board with more than 7 members? I'm still sorry for you. Okay. So sometimes those meetings are going to take longer than an hour. So if anyone ever been in a situation where you're debating and you're hearing like the same things over and over again, and you just want to say, can we just vote on this? What do you do to make that happen? What do you say?
During the meeting.
No, you say 3 words. Call the question. Diego, do we have? No, we're all out. All right, there we go. Call the question. Call the question is basically saying, listen, I want to vote to whether or not we're going to vote right now. So that's a real easy way to cut it off, okay? Another interesting thing is that if maybe you even haven't made a motion yet, there's the one guy that wants to change all the mailboxes in the entire HOA, or he wants to do something crazy that doesn't make any sense, and he won't start talking about it, and everyone's getting involved. Can you make a motion? Can you just, if you want to just end it, can you literally say, I want to make a motion to approve this project for $1 million, you know, right now, or even $1,000, and can you make it and then vote against it? Are you allowed to do that?
Sure.
Absolutely you are. So that's something to think about, is that if you feel like something's dragging along, you can literally make a motion that's exactly what the person is asking for, so that you can get a vote on it, so you can get them to just move on. I've rarely seen anyone do it, but you actually can do it, and it's a very smart way to move things along when things are just dragging. All right, declaring the ground rules. This is another interesting one. So what we suggest, what I mean here really is just reminding people that this is what kind of meeting is this we're talking about? A what meeting? A board meeting, and it's not a members meeting. It's not a members meeting. The members meeting is the annual meeting. It's a board meeting. So what happens is you're always going to get new people showing up. Most of the time it's the same people that have been there for a long time. They know the rules of the game. But I would suggest that it's always good to just for every meeting remind everyone, because you might have somebody new that's never done this before. You know, and they think this is like a town hall. So just remind everyone, hey, this is a board meeting. This is not a members meeting. You have the right to sit there and listen, and you can ask questions under certain guidelines, but this is our meeting, so just make sure you understand. If you have any questions, you know, feel free to, you know, we can talk about it later. And what we even have, some of ours we suggest where it's been an issue, is you can take there's a owner's right to speak kind of guidelines, and then put it on the back of the agenda, just so you can say, listen, if you want to understand how you can speak and when you can speak, it's on the back of the agenda. And again, it's one of those things where you don't need it until you need it, right? So you might have it, it's never an issue for 3 years. All of a sudden, one day you're like, oh, thank goodness I have it. These 3 new people in here, now I can keep them under control. And then it's like you're not picking on anybody as well, because it's something you standardly do.
And we limit the time too, it'll be like 50 minutes or so.
Absolutely. I'm going to get a little more into that in a few minutes here. The next key thing, real common sense ones, follow the agenda. So why is it important to follow the agenda? I forgot to ask this. Is anyone here on HOA, in an HOA? All right, everybody's condo. Okay, so good. So why is it important to follow the agenda in a condo? Well, because it's the law. I mean, you have to follow the agenda. If someone wants to just talk about, you know, something completely new, I think we should completely throw away all the gym equipment, put something in new. You can't just start talking about that. It needs to be on the agenda so that it was posted and people could know that's a topic and that they'll show up. If you want to, if it's a valid point, you can vote to put it on the next meeting agenda, but you cannot talk about it. Yes?
What if somebody starts up and starts, we've had people do that in meetings, and what can we do? I mean, we have the gavel, we have whatever, and they don't stop. What can we do?
So what do you do when people just start bringing up random things or whatever? As again, I would go back to owner's right to speak policy, put it on the back of the agenda, start every meeting with, we're going to go through the agenda. This is a board member meeting. Members are allowed to speak and ask questions. You're not allowed. We don't need you to stand up and do a diatribe. It's asking questions, and but you have to do it only when recognized, and you have time limits and so on. So I think it's just setting those ground rules up front, and then as soon as they do, if someone breaks off it and say, "Excuse me, that's not on the agenda. We can't talk about that." Right? And owners, I mean, it's a little more advanced, but I mean, owners do even have the right to force something onto an agenda if you want to. You can ask those guys about how to do that. You just need to get a small group of them, you can get something added, yes.
Even though agendas are posted and sent out to the ownership, should they be printed and handed out as people enter the meeting?
Yeah, should they be printed and handed out? You don't have to, but I would say absolutely you should. You should have copies of the agenda there, just because most people don't remember to bring them. And then, again, you can then put the notice on the other side about members' right to speak.
Can you add other businesses into the agenda?
Can you what?
Add other businesses into the agenda, non-specified.
No. Why don't you ask the attorneys about that? I'd say, I can't imagine a scenario where you could just say a miscellaneous, because that's the whole point, is you're not supposed to talk about miscellaneous stuff. In an HOA you can, but not in a condo. And I've hit on this already, letting members speak. So, yeah.
Yeah, I was just wondering, when you talk about not being able to add anything, what we typically do is have the meeting and don't allow any speaking during it.
Right,
And then afterwards, once the meeting's
right.
we don't really stop them bringing up anything.
Yeah, so after the meeting, you can adjourn the meeting and you can say, look, does anyone have any informal, some people call it good and welfare, some people call it Q&A, and you can just generally, you can say we've adjourned the meeting. But you can talk to them about that as well, because I don't want to say something wrong. Yeah, anytime you say can we or whatever, I'm going to try to say, well, let's ask them about what you can and can't do exactly, because I don't want to say it wrong. Right, right, right. So,
What's the verbiage for that call question? That you make a motion to call the question?
yes, I'd like to make a motion to call the question. Yes. Yeah.
Thank you.
Yeah. So then, one of the other key things here is like, so if there's a really important project that's going on, say you are, I mean, we've had this happen a few times. We're going to demolish the entire clubhouse, and we're going to build a new clubhouse. So where should that be on the agenda? At the beginning of the agenda or the end of the agenda?
The end of the agenda. Get everything done first.
No, honestly, beginning is what we would say, is because you're going to have to bring in an engineer, an architect. You're going to have a whole bunch of people that are sitting there the whole time saying, I came here, I want to talk about that, I want to talk about that. They're waiting for it. So the best thing to do is get it over early, okay? And if you're doing that, has anyone ever seen it where, like, you could, I shouldn't say is it legal. Have you ever been in a situation where the board, you're allowed to let the owner speak, but say it's a huge project like this, the board can talk about it completely, and then they can vote on it, and then let the owner speak. Can you do that? No. Actually, you can. It's just really stupid, okay? So you can actually do that. You have to let them ask questions, and you can even make the decisions first, but it's just a really bad way to do it, all right? So just make sure the board speaks, then they get to speak, and go from there. Next thing is Robert's Rules. Is anyone in here like a Robert's Rules expert, like a Robert's Rules ninja? All right, well, I'll ask one request. Don't use it on anybody, okay? Just like if I'm a black belt, I'm not going to use it on anyone. They're very complicated, they're kind of overkill, and you really just need to use the basics. And if you've got someone that really knows it really well, you can even delegate the authority for them to be the parliamentarian if you want, but don't let it overwhelm you, because it can cause all kinds of issues. You need to make motions, make second, call the question, table things and so on. Just keep it simple, and if someone tries to railroad you into the details, you rarely have to follow it verbatim. The next one is a real important one I think we've hit on already. Does anyone know who I stole this from? Don't criticize, condemn, or complain. How to win friends and influence people. Dale Carnegie. This is like principle number 1 at Dale Carnegie. Don't criticize, condemn, or complain. So, have any of you guys ever been in a situation where you felt like, all right, I'm going to get attacked today, and I know who's going to attack me, they're going to attack me about so-and-so. So, when that happens, one of the best things you can do is just remind yourself in advance, how am I going to respond? I can use my gavel, I'm not going to throw my gavel, but I can use it, but I'm not going to respond back. So you can, literally script it out. Something to the effect of, listen, I appreciate your comments, but I disagree with them completely, and thank you for your time. We're moving on to the next item. So just be prepared for it, and don't let them throw you off your game. Because remember, sometimes when crazy people act up, it's not you, it's them. You just keep telling yourself, it's not me, it's them. It's not me, it's them. Last one here, yes.
I have a question in regards to the Robert's Rule. I'm a new board member. My first meeting will be next week, but I was told by another board member the board members' vote really doesn't count as long as one person makes a motion and a second, and someone seconds it, that's the decision. That's the board's decision.
No, let's talk offline, because that's crazy. So, let's talk offline on that. So, last thing, minutes are not transcripts. So, has anyone ever had someone say something, I'd like the minutes to reflect blah, 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 blah? Have anyone ever had that?
No.
Someone say that? What do you do if someone says that?
Sure, no problem.
That would be the criticize, condemn, or complain. So, don't laugh at them and say, well, listen, thank you very much for your input. We don't put that kind of stuff in the minutes. All we put in the minutes are the decisions that were, the motions and the decisions that were made. There's no color commentary. And you can ask these guys about it. You know, you don't want these things super detailed. They can come back and cause problems for you later. You know, so-and-so, I'd like to put in the minutes that there's a trip hazard on the sidewalk. That's wonderful. That's what happens when 7 years later someone falls and breaks their neck. You didn't fix that, and they'll find it. These are the good lawyers. There's the other lawyers that will find that stuff. So anyway, so those are my 9 steps. I went through them pretty quick, but again, they're on the Florida Association News blog, and you know you can go here and subscribe to it. Also, if you go to our website, you'll see if you're a newer board member and no one's ever really told you what's it like to be a board member. We've written a board member primer. And you can download it. It's about 15 pages long. It describes the roles of all the different members of the board, particularly the officers. And it has about 7 or 8 articles that you can read that kind of explain some of the key things or the trickier things that you need to understand. And again, it's not legally oriented. It's more just practical, how to be efficient and effective stuff. So that was all. And if anybody has any questions about anything afterwards, feel free to chase me down to a break, and I'll be glad to answer. So,
Very nice.
yeah.
Let's say you have a management company, and they send out a property manager, and the property manager just goes through. It all looks good on paper, but you discover that $1 million is missing. The property manager has.
You guys come on up here while we're so. Well, hold on one second. I'm just going to, the folks from Eisinger Brown are going to come on up and start getting set up while you're asking this, so I don't want to slow them down.
So the property manager's gone rogue and he's done all these things, hid these things, and $1 million is missing. Is it the property management company's responsibility?
That's when you call you have a good attorney, you call them, you get them involved. That's a key reason why you want a management company, I will tell you though, is that the management companies work under the association's insurance, but if the management company were ever to do anything or their employees do anything that's grossly negligent, we have additional insurance beyond yours. So we have the ability, it would fall back on us. So on a management company. So. All right, great. All right, thank you guys very much.
Hi everyone, good morning, afternoonish. Thank you guys all for coming, and thank you to Campbell for setting this up and for all the efforts that was put in. There's tons of food back there if you guys haven't had a chance to eat. Please, we don't mind if you want to get up. My name is Alessandra Stivelman. I'm a partner at Eisinger Brown. This is Gregory Eisinger and Carolina Shear. And we're going to be doing this a little bit of an unorthodox way. We kind of all chime in with stories and opinions. We want it to be interactive, but at the same time, we have a lot of material to cover. So, if the question is directly on point, feel free to raise your hand. Otherwise, we'd be happy to stay after and talk to you guys. If you haven't signed in with Josh from our firm in the back there, say hi, Josh. Josh went around. Make sure you sign in because that's how you're going to get your certificate, your board certification. So we're going to mail it to you. Make sure all the information on there is correct, and you should get it within like 2 weeks, maybe. Okay. All right. So did I miss anything as far as intro? Oh, our firm is located in Hollywood, but we service clients throughout the state of Florida. We also have an office in Gainesville. We represent about 700 associations throughout the state, from HOAs, condos, and co-ops. And this is our niche. This is what we do. I'm board certified in condominium and plan development law. The this is what we practice on a daily basis. So hopefully you guys will get a lot out of this, and we'll walk out of here knowing a lot more than when you came in. So we're gonna go ahead and start.
Where's the?
There we go. Okay, so we have a lot of slides, but we're gonna go through them a little bit quickly. If you guys want a copy of the PowerPoint, we'd be happy to give it to you guys. Just email us after the event. Our cards are all up there, and we can send it to you, so there's no need to take pictures or anything. We're gonna try not to read verbatim and just summarize it to you guys so you get a good idea what we're talking about. So we're gonna start with, what is a condominium? The term condominium is a type of ownership in real property. It's created pursuant to Chapter 718 of Florida statute. So you might hear a lot of people saying that condominiums are a creature of statute. It's comprised of units that can be owned by more than one person, and appurtenant to each unit, you have an undivided share in the common elements. Now, the association is the entity that manages the condominium, or the HOA. The difference between, I don't know if we want to, there we go. The difference between an HOA and a condominium is that in an HOA, you don't have ownership of the appurtenances. The association owns the HOA property, and you own your lot and your community. But as far as maintenance obligations and who's going to be responsible for the roof, that all varies, and a lot of times that goes into your governing that's from your governing documents, and you'll see that when we get to it. Do we have any co-ops?
Yes.
Oh, okay. So co-op is actually very interesting because it's an ownership of real property, but its legal title is vested in a corporation. So it's not technically that you own the property, you have a percentage share in the entity and in the corporation. So they're very common in New York, but not very common here. And it's a different type of entity. A lot of the statutes are very similar to the Condominium Act, but there are some differences because it's a different type of ownership.
You don't own the land, do you?
You don't own the land, you own your shares in the co-op.
However, most times, the co-op may own the land, or may be renting the land. You're probably thinking of if there's a land lease.
Right.
So the co-op itself may or may not own the land.
And instead of getting a deed, you get a lease to your unit. So it's a little bit different, but a lot of the same principles as far as Florida statutes apply to co-ops.
Well, how are the taxes broken?
So the taxes are part of
The real estate tax.
The real estate taxes are actually part of the association assessments. So you don't pay your taxes separately, you pay it as part of your assessments to the association. So both an HOA, a condo, and a condominium, you have the ownership in a certain amount of real property or shares, and then you have the association. And the association is the entity that governs the condominium or the HOA or the co-op.
Okay. The most important thing to remember when you are a member of an association board or a member of an association is that an association is actually a business. It's 9 times out of 10, it's a not-for-profit corporation. It's governed under, obviously, Chapter 718 or Chapter 720 or Chapter 719, but it's also governed by the statutes that are applicable to for-profit and not-for-profit corporations. There are many components of an association that you have to keep in mind, not just the meetings and the budget and the assessments. You have regulatory components, you have the enforcement of covenants and restrictions, you have the rules and regulations that are promulgated by the association. You have the fiscal component, just like any other corporation in this country. You have to do your budgets, your reserves, your assessments, your insurance components, governmental, you have to run your elections. These are tiny little democracies. Some of our associations are actually larger than some city governments, and they're run very similar to some of our city governments. You have officers and directors who have fiduciary responsibilities to the members, and you have the equivalent of what sunshine laws are in our state government, meaning that things need to be, business needs to be transacted out in the open, with an opportunity for the membership to participate and review the records of the association. There's also the managerial component, which is the day-to-day operations, the management, maintenance, a repair, replacement of the key components of the association, and the maintenance of the official records, which is probably the most neglected component of an association, is proper record keeping and record management.
On the fiduciary responsibility, what do you do if your HO, if your association is paying bills like that, you currently, you cool that?
So we're going to have a specific section on fiduciary duties and explain what they are, because it's a very broad word, but on the day-to-day operations, or what it really means and what the recourses are it's a different component. But we'll address it a little bit later. So we talked about associations being creatures of statute. Alessandra mentioned that we have a Florida Condominium Act. We also have a Florida Homeowners Association Act and the Co-op statute as well. And I previously mentioned that we have the for-profit and not-for-profit statutes. We also have a regulatory component, which is the Florida Administrative Code. That really kind of gives us the statute's very broad, and then the regulatory code kind of gives us a little bit more instruction on what we can and cannot do. That's where we get, when you ask me, I recently did an election for one of our participants here, and I'm very strict about how we open the envelopes at the election. Well, that all comes from there. In addition, though, there are so many things that you need to keep in mind as board members. Who likes to tow vehicles? You have to make sure that when you tow a vehicle, you're in compliance with statute, or you're going to be held responsible. There's Fair Housing Act issues with screening tenants, issues with emotional support animals, issues with, and that would be ADA, FHA type situations. Fair Federal Telecommunications Act. People have issues with people putting up satellite antennas on their balconies. Can they do that? Can they not do that? What are the regulations? Landlord-tenant. A lot of our associations collect tenant deposits from tenants. How do you do that? What happens when there's a claim on the deposit? Who pays the deposit? How do you return the deposit? Chapter 713 is a big one that I deal with a lot. You all enter into contracts with contractors to make substantial repairs to your community. What happens if somebody doesn't pay? How is the lien filed against the association? What happens with subcontractors who don't get paid? So this is just a little bit of an understanding that condominium law itself, or association law itself, is not limited to the Chapter 7, 18, 19, and 20. But you're really touching upon a myriad of different areas of the law. So we're kind of jack of all trades specific to the condominium association or association world. Okay, so when we talk about the hierarchy of association law, and it's not a complete hierarchy, because we'll learn later that unfortunately statute doesn't always govern. We have our Constitution, United States Constitution, and everybody knows that trumps everything else. And below that we have the statutory enactments issued by the Florida legislature, the Florida's, forgot about that one, Florida Constitution. Then we have our statutes, so Chapter 718 for condos, Chapter 720, and 719 for co-ops. Below that, we have the administrative code, which I explained to you, gives you a little bit more instruction on what you can and cannot do. Then at the individual association level, you're going to have your constitution, okay, which is your declaration of condominium. Below that, you have your articles of incorporation. The articles of incorporation are what create your governing entity, which would be the association. The declaration essentially creates the condominium, and it dictates that this property is subject to the condominium form of ownership. The articles say this property is being governed by this association. You also have the bylaws, which are the operational instructions to your association. And below that, your rules and regulations, which are adopted by your board. And you may have master covenants. Some of your communities are subject to a master association as well. Always keep in mind that your rules and regulations have to be consistent with the provisions of your declaration, bylaws, and articles. The declaration will usually have your use restrictions, So what you can do to the facilities, to amend or make changes to your structure, permissions or prohibitions on pets, restrictions on ownership. Those are the kind of things that you should expect to find in your declaration. Your bylaws will have the operational components, how many board members, how they vote, when you have your meetings, how much notice your meetings need to have, so on and so forth. And by default, if it's not contained in your documents, you go to the statute, with some exceptions.
Right, so with this, it's really important to remember, it's not so simple where all you had is a hierarchy, right? Because sometimes the statute would say, unless provided otherwise in your governing documents, or it will have a limitation. So you always kind of have to look at them in conjunction so that you understand the whole picture, which is why you should go to your attorneys whenever you have anything specific. But we get asked all the time, can we pass a rule that fill in the blank? And you just have to keep in mind, the main important thing about rules is they have to be reasonable. And while the board may have the authority to pass them, if they have to do with the use of the lot or the condo, you have to pass it at a board meeting, but you have to give the 14-day notice and a copy of that rule prior to establishing the rule. And some of your governing documents may say, well, the rule needs to be sent out via mail to everybody 30 days prior to the effective date, or little things like that that often get ignored. So it's always important to look at your documents, make sure that the rule, it can be more specific, but it cannot contradict anything in your governing documents.
Particularly to condominiums, do the rules and regulations need to be recorded?
Okay, that's a very interesting question. The gentleman asked if, particular to condominium associations, do the rules and regulations need to be recorded? And as for condominium associations, the current state of the law is that no, they do not need to be recorded because there isn't a definition of governing documents that includes rules and regulations. For HOAs, interestingly enough, rules technically, although I don't think it's great, but technically rules and regulations are part of the governing documents, so yes, they do need to be recorded in HOAs. It's an impracticality because your rules and regulations are really your most fluid components of your governing documents, and recording every single time is you're just creating a burden.
We didn't ask this, how many condos do we have? Everyone, any HOAs?
Yeah, HOA. And one co-op.
And one co-op, okay.
Okay. All right, so this pretty much summarizes what I explained before as to the nature of each of the components of the governing documents.
Carolina?
Yes.
In reference to if we have governing documents like the Kaufman Law that you brought up to my attention, okay? If the topic or the item do not give us specifics, typical, we are allowed 2 dogs, but no weight is stated.
Okay, so the example is she's asking me about Kaufman, which we'll talk about a little bit later. However, the question I think you're asking more is if your governing documents say 2 dogs, for example, and no other information, no weight limits, no this, no that. So this could go, the answer is it depends, and it depends on what you're trying to do. If you could adopt a reasonable rule and regulation saying that I would say you could restrict a weight limit.
You'd have to
Based upon a reasonable rule and regulation, you allow dogs, but because of X, Y, Z reasons, however, it's not a golden rule, and I can't guarantee that it won't be subject to challenge. And today, unfortunately, there's so much abuse that it's not, and we'll deal with the abuse of that later.
Meaning is that condos are excluded from the ADA.
It
Depends.
We'll get into that. We have a whole
Everything
section
we
on
say
it.
is it depends.
Yeah.
Sorry, guys. But
Anyway,
yes.
we do what we do. It's a
Yes.
We were told that with support animals,
We'll get to support
We'll get into
animals.
that you were entitled to interview them.
We'll get into all of this.
No, we'll get to
And
it.
the article in the Wall Street Journal last week, about interviewing the pets. And come up with-
And I'll talk about this directly because we do have an association that came up, so we'll get to it. Hold off just a little bit.
I know, that's the most exciting topic.
Yes.
And we know that. Stay tuned. We'll leave it to the end. to keep
Board
it on
animals and
And unauthorized tenants, those are, we getting calls every single day about those two topics.
Airbnb.
Airbnbs as well, and those are, the hot topics, especially in South Florida and the ever-changing law.
We want to keep you till the end, so we save all the fun stuff.
Exactly. And before we go on, I know about 90% of you are directors, if not more here. Thank you. You guys are all putting your unpaid volunteer time into your communities, and from us, from the managers, from everyone that does get paid for what we do, we really, really appreciate it. We appreciate that you guys come to these events, because as I'm about to talk about the board certification, you guys as directors have two options. You could sign a document saying you've reviewed your governing documents, your rules, you've read everything, you will uphold your fiduciary duty and do the best you can, or you could come to a class like this and actually learn about what it means to be a director. So thank you all for coming here today and taking your time to learn about your duties as directors. As I just said, you have 90 days after you become a director, this is statutory, to either do this class or to sign a document saying that you're going to be a good director. All of you will get certificates within 2 weeks of this for attending this class. And as long as you guys are directors, you don't have to redo the class. We think it's a great idea to come every year. We do a little legislative update. It's always good. We change these classes up to kind of hit on some topics that are more, I guess, hot topics these days. Airbnb is something that maybe we didn't talk about a few years ago, but now we have to talk about it at every single lecture. So we do thank you guys for coming. Yes?
I'm sure this is the right section to ask, but two questions. We had a board member that said that because he was now certified, that he could certify other people and sign it. No.
We have to be certified by the Department of Business and Professional Regulation in order to provide this course to you. It's a very rigorous process.
I told him it was illegal and we needed to do that. I thought. We also have, we're 4 buildings, Meadowbrook buildings, and this may have to do with the documents. 2 of the buildings, when we vote for our fifth corporation representatives, we put it in the ballot. 2 of the buildings don't have it. The president gets to pick whoever they want. Would that have to do with their bylaws? I mean, to me, that doesn't seem...
We would have to review those bylaws and the declaration to see what your
The
documents
master
say.
declaration, because it may be up to the sub-association to decide who they appoint to the master board, or the master declaration may have a procedure for how those people get appointed. So it really depends on your governing documents.
Okay.
Are you a Kings Point person?
No, Meadowbrook.
Meadowbrook, okay, we've represented Meadowbrook before.
Yeah.
So yeah, it really depends what your master documents say. Some of the documents will say that the board gets elected for each subdivision, and then that board gets to appoint someone to the master association. That's generally how it works. Or it'll say the president of each board is automatically appointed as the master representative. But it depends on your documents.
Then they get to pick whoever they want to be the other representative on our master.
We have to look at your
It
documents.
depends on the documents, and the other thing that is also really important when you have a master and subs is you have to look at who is the member of the master. Is it all the unit owners, let's say, from all the sub-associations, or are the sub-associations the members of the master? And that's going to impact how they vote and how decisions are made, so it all depends on the documents.
So, you guys are all directors, but you're also unit owners. And as unit owners, everyone has responsibilities to your corporation, to your governing entity. One of those, and probably the most important responsibility, is to pay assessments. This is not negotiable. Whatever the assessments are, as long as they were passed properly, you must pay them. Our biggest defense when we file lien foreclosure lawsuits, our biggest defense is, well, they took our money and they built a tennis court and I didn't want that, so I don't want to pay my assessments. Assessments are like taxes. If you don't like what the government is doing, you can't forego paying your taxes, and it's the same thing with assessments. So no matter what, you have to pay those assessments. You have an obligation to use the common elements. Everyone's condominiums here, so I'll try and stick to just condominiums. You have common elements. You have a swimming pool. You have a gym. You have an obligation to use those in such a way not to infringe upon the rights of the other members. So if there's rules that say you can't have pool parties, you have an obligation to respect that. And you can't have 50 people come in that aren't members using your community pool. You have an obligation to allow the association reasonable access to your unit. So if there's a leak and the association says, hey, I have to get into your unit to fix the leak that is occurring in one of our common element pits that's only accessible through your unit, you have the obligation, the duty to let that person in.
We require a key.
And a lot of people do require keys. And right, it goes both ways.
It goes both ways. If you're gonna have a key, make sure you know exactly who has access to it. Keep it under lock and key. And when you do access a unit, never go alone. Film your entrance and make sure it's properly documented and the proper notice is provided ahead of time and you have it documented in writing.
Just because.
My understanding is that directors have responsibility and officers have duties. And it's the responsibility of the directors to make sure that the officers do their duties.
Not necessarily, because a lot of times the directors are the officers and vice versa. So generally, most governing documents will say that the unit owners or the homeowners elect the directors, and then it's up to the directors to appoint the officers.
Yeah.
Sometimes your documents may allow someone to be an officer who doesn't reside or is not an owner, but that's rare, and it doesn't really serve the interest of the community to have an officer doing the day-to-day operations that doesn't have an interest in the community. So everyone's a director, and then you appoint officer positions. But one thing to keep in mind is that every single director has one vote. It's equal. Whether the president or the treasurer, it doesn't really matter because the decisions have to be made by a majority of the directors and the officer positions don't come into place. That's just really for the purpose of, okay, the treasurer is going to review the payments and be on top of XYZ, and then you can allocate responsibilities, and sometimes those are allocated in the bylaws as well.
So going back to the access to the unit, just because you have a key to the unit doesn't give you carte blanche to go into a unit whenever you want or whenever you please. The purpose is for an emergency. If you need access to the unit for any other purposes, reasonable notice must be provided and arrangements need to be made. So, you know, I've known associations where a president or somebody who's extremely overzealous carries around the keys in his ring, and he just comes into whatever unit he feels like whenever he wants. That's trespass. That's not allowed. So you want to make sure that with every right, there is a responsibility and there are limits.
And don't use self-help. If you need to get into a unit and it's not an emergency, make sure that you talk with your legal counsel because you can't just go into that unit. You may need to file for an injunction or get a court or arbitrator saying that you have the right to go in there.
It should really be used if there's a fire, if there's a leak, an active leak. Other than that, if there's mold and you think, you know, look, I smell some mold coming there, right, you can send them a letter. If they don't respond, you can go to court and the court will give you immediate access. A police officer will come, will let you into the unit, and you know that's the proper way to do it also. You know, with the gun culture today, I don't think people should be, barging into
the relative
units.
comes down 3 o'clock in the morning, and the relative says, I don't have my key.
Well, that's the next topic. That's not an emergency. You are the association. You're not here to be making services, key services or access services to unit owners for realtors, package deliveries, any of that. If you're lending out your emergency key for those purposes, you're subjecting yourself to a huge amount of liability. Keys should only be for emergency purposes.
In terms of entry into a private area to repair something that is a common area element, is there a responsibility of the building to repair private elements to get into a common element? In other words, if someone goes into someone's apartment to repair a pipe and has to go through a bathroom wall that has tile on it that is not replaceable because
You have to repair the tile, and it depends.
Consequential damage. So it depends where, it depends what your documents say, it depends whether the repairs to the limited common elements or to the unit itself. And a lot of documents, some of the older ones actually, will say that if the association has to enforce their maintenance responsibility, and as a result of that, there is incidental or consequential damage, and they're responsible for it. Others don't, and it's one of those gray areas of the law that we have to determine how to proceed. I've had an association that had to tear up the first floor of every single unit because they needed to do a whole pipe project underground, and there was a lot of issues as to who was responsible to replace a tile and the cabinets and all of that.
So it's dependent on the document,
Depending on the
not
documents and
on the
situation.
law.
Right, as a general rule, the association is responsible for the drywall, and then everything else inside that drywall is the unit owner responsibility. So unless your documents say something otherwise, or there's circumstances such as a negligence action or an intentional action that caused the damage, it would have to be reviewed on a case-by-case basis and looking at your
And
declaration.
it also depends whether it's an insurable act and whether or not you filed an insurance claim and the insurance compensated you for the full amount, and now you're not using that amount in order to repair what you were paid for. So a lot of elements go into it.
So, yes.
You just brought up the subject of insurance.
Or-
Will you have a section on that?
I'm not sure, but
Depends on what the question is.
yeah.
Well, you know, we were told by our insurance company that if we go to hurricane windows and doors, that we'll probably save, 40, 50 grand in insurance premiums. Well, our insurance went up 65,000.
Everyone's insurance went up this year.
Yeah.
That's just been an overall, I mean, I've been to so many annual meetings this year and budget meetings where the owners are complaining what's going
There's
on.
been a few hurricanes in the past few years, and
Yeah.
when that happens, the next few years, insurance slowly creeps up because it takes time for the insurance companies to start paying off all of these damages, all of these claims, so it's kind of a delayed increase. And we're seeing that from some of
What
the
if
past
what
hurricanes.
if you didn't want to carry you have like some ridiculous deductible, about $650,000 deductible. It's a percentage of the value of your building. Well, you never hit that amount, and if you put in a claim in,
Well,
they raise your premium, even though they don't give you any money.
So this is a whole different topic that we can speak about at length, but one thing to keep in mind is with insurance agents, just like attorneys, just like management companies, they're all vendors. And if you are not happy with what you're getting, like you need to be checking your insurance on a regular basis, speaking with your agent, seeing what your options are, making sure you're properly insured, because on the little thing, maybe you don't want to file a claim, but you need to be properly insured in case a hurricane comes and blows up your building. I mean, you need to consider that. So we can have the conversation after if we don't touch on it today.
We've done courses just on insurance where we've spoken for 2 hours on insurance issues and claims and how to address those. So, I mean, yeah, we could go forever on almost all of these topics. We're trying to hit, just the main ones and give you the brief overview. And after, if everyone has, specific questions pertaining to your community, we're happy to stay around and answer some of those questions. But back to just the duties and responsibilities as owners. One of the biggest ones is to participate. You have a duty to participate in the affairs of your community. You have a duty to vote. You have a duty to attend board meetings. Now, only 10% of your community may be fulfilling this duty, but guess what? That's egg on the other people's face if they don't like what's happening in the community. So, it'd be great to have a board meeting with a 70, 80% turnout, but it's very rare. But that is a duty when you buy into a community association. You have a duty to cooperate, to maintain harmony. You have a duty not to, every single declaration has a nuisance provision that says you cannot create a nuisance. You're living very close to your neighbors. If you're blasting music, that is bothering people next door, and a condominium should not be for those people. You have a duty not to have smells coming from your unit. We actually have a lot of smoking issues where people are smoking cigarettes, marijuana, whatever it is in their units, and it's transferring over to the units next to them. And in the past, that was never a problem because people said, look, everyone has a right to smoke, and now that right is kind of being attacked because people are living next to each other, and I'm not a smoker. I wouldn't want smoke coming into my condominium unit, and if that's happening, then the condominium association has to kind of step in. And there's been a lot of cases now that have been litigating whether people have the right to smoke in their unit if it's getting into other people's units or the common elements.
What's the outcome? I mean, even if they smoke on their patio.
There has not been, and I actually wrote when I was in law school, I wrote a 30-page paper on it. That was 10 years ago now. And there still hasn't been official word of whether there's the absolute right to, but we take the position that's a nuisance. Just like, back in the day, it's a trespass, it's a nuisance, there's a lot of,
How do you stop it? I have 5 neighbors, they all smoke between cigarettes and marijuana.
So marijuana is a different issue, which I'll touch when we talk about reasonable accommodations. But from cigarettes, there's filters that you can put, there's different remedies that you can take, either the owner or the association, in order to.
But here's the thing, you guys are here wearing your board of directors hat, okay? And typically, as counsel for the association, this is a touchy issue because we don't want to have our board be overly involved in a dispute amongst 2 neighbors over the smoke.
There's an overall stance.
There is no stance, and that's exactly why we try to say, have one owner get into it with the other owner, because since there is no law currently, and an association has not been involved in it as of yet, where it's definitive, it's hard for us to get into that. Nobody wants to be the guinea pig.
And there's always the option to amend your documents. So, I don't know if you want to.
Actually, in the last few years, I've probably drafted about 10 different no smoking amendments. And they're all different, slightly different, whether it's there's no smoking within units. And if it's passed properly, we generally recommend grandfathering some of the people in, because they're going to say, hey, that you're taking away my right, and we try to avoid litigation, we try to avoid stepping in between 2 unit owners. We generally act as mediators a lot of times, because if there is a lawsuit, the association is getting dragged in. So, but I have passed, or many associations have passed, these no smoking amendments: no smoking at the pool, no smoking on common elements, putting a designated smoking area for people to go outside and smoke it in the buildings. There's actually been a few condominiums developed recently that have just been no smoking condominiums, period. But that's a very, very hot topic in today.
Does that also apply to odors from restaurants that are in the building?
Well, that's the original use, when they would say there's no nuisance, no noxious odors coming, because there would be people cooking that, they would leave the door open, the smell would come out, there's restaurants coming in. Now, today, everyone has the right to breathe clean air. And if something is bothering them, if some kind of air, odor is bothering them, there's ways to put door flaps, there's ways to, there's water or air purifiers. There's a lot of different things to do to prevent smoke or noxious odors from restaurants or whatso from leaving your unit and kind of containing in your own unit.
Okay, so we talked about what obligations and duties a unit owner has. And the association also has obligations, duties, and certain powers. They're generally set out in the Florida statutes, in the governing documents, or in your proprietary lease. But those powers generally include the power to manage property, the power to contract, to sue and be sued, power to make and collect assessments, power to lease, maintain, repair, and replace association property, and the right of access to units. So those powers are very general in nature, and as an association, you have to be very careful as to how you exercise it. Now, as we talked about before, and I know you guys had a great presentation from Campbell before about best practices with board meetings, so I'll try to go over this pretty quickly. The association is administrated by the board of directors. The board generally is composed of 5 members unless otherwise specified, or if there's fewer units. And HOA's board require at least 3 board members. The boards generally have a president, secretary, and treasurer. Those are the officer positions. And unless your bylaws provide to the contrary, the board appoints the officers. So when you have an annual meeting, the directors are elected, and right after you have an organizational meeting, and one of the 2 important things that you always want to do in an organizational meeting is you want to appoint the officers, and that can be done by agreement or by a vote, like you would with any other decision, or, I just lost my train of thought. Signatories on bank account, thank you. You want to decide who's going to sign your bank account. Who's going to sign the checks so that you can pay your vendors and take care of all of that.
And we always recommend that you have at least 2 signatories on every check.
Right.
You want to have a checks and balances. You don't want to have someone have free reign of your bank accounts.
Right. And remember, officers and directors cannot be paid. So, this is a fiduciary duty. So this is a topic, it's a word that's thrown around a lot and no one really seems to understand it. So officers and directors have a fiduciary relationship to the unit owners. They have an obligation to act in the best interest of the association. They cannot solicit, offer to accept, or accept anything of service of value for which consideration has not been provided as a result, to their benefit, as a result of them serving on the board. And that goes for their immediate family or from any person that's providing any services. So you could say, well, the person on the board is the husband and the wife owns a company that does contractual work or does general GC work, and you know, it gets a little iffy. You always want to do the proper disclosures as far as conflicts of interest. Keep that in mind. I don't know if we go into that in detail. But there are very specific conflicts of interest statutes that you need to abide by, and you should always disclose.
Can the members pay for the officers or directors telephone bills?
No.
Because in our budget, like our telephone bill is like thousands.
We had that issue with another association of ours.
Yeah, no. You want to have it separate. In order for you to put it in your budget, you want to make sure that the association has their own cell phones. And I've even had problems where management companies will provide cell phones to different security and whatnot, and it becomes a really big issue if there's ever a transfer or a transition. So you don't want to have that. You want to keep it separate. You know, you want to have your due process, your separation of powers, everything that you would consider in government. You want that to apply to your association.
And the same goes for travel expenses. There's no reason that any of you should be traveling to New York or to Paris. It goes for meals.
About to the Bronx.
It goes for meals. We have some associations are.
Late night pizzas.
You're getting. I mean, if there's a discretionary fund for those kind of things, for working meetings where you order pizzas. But what I'm getting to is we have some associations where our board members are out of towners or they're snowbirds. They may be in Canada. They may be in California, and they've often asked us to have the association pay for their travel fare so that they can come and attend the board meeting, because they're saying that that's, the answer is no. Basically, don't do it.
Can the association pay for property manager cell phones?
If it's contracted,
Yeah, it depends on your contract.
It's not contracted, they just decided to pay for all the cell phone.
I don't think there's any basis for the association to do that unless it's an agreement between the association and the management company.
Okay, so board meetings. Oh, sorry?
Yeah, just a quick question. In terms of conflicts of interest, and I think it is not, well, I think it's obvious in Florida that it goes well beyond conflicts of interest in terms of corruption. Can you give us any updates on what's going on with corruption in terms of boards and selection and money that flows under the table? Because it does occur.
So first of all, there's a statute that strictly prohibits that. There are recent legislative enactments that tend to beef up. We didn't have much meat and potatoes to them because they already existed. But there are criminal penalties that may be imposed for things such as bribery and kickbacks. I mean, that's strictly prohibited.
If you can find it.
Yeah, but that's
A
where you can find
Right.
them.
A few years ago, they actually, you know, these were regular just criminal statutes. A few years ago, the legislature put these type of statutes right in the Condo Act because it's been a rampant problem in mostly South Florida, you know, not throughout the state, but I'm sure it happens everywhere. But they actually made it criminal in the Condo Act to be taking money improperly or doing some of these things.
Right
And
down
so-
the road, they took them out in handcuffs.
Right, so we have a lot of associations that come to us when they get on the board, new board members, and they say, we know for a fact that this past president was getting kickbacks, was doing XYZ, was getting favors. The problem is, and then they report it to the police, And there is special units that investigate fraud within associations in most counties and cities, but the problem is that you have to be able to connect the dot for them to pursue anything. And that's the really hard part. And to do that, you may need to get a financial audit, you have to go above and beyond, and it costs the association a lot of money. So it becomes a risk-benefit assessment. Do we really, how much money do we think went missing, and how much is it gonna cost to pursue it? And even if we prevail, is the individual collectible? And that's really the analysis that needs to go on when it comes to that.
So it's important to have an appropriate checks and balances system. We know it exists. We want to say that, you know, most people are honest and they're looking out for the best interest of the community, or they're overzealous in the interest of the community, but it does exist. And that's why, you know, think about the smell test. Does it pass the smell test? Is it something that you would, you know, tell your priest or your rabbi about, kind of situation? Govern yourself. This lady had a question, and then we got to keep going.
Yes, I don't know where the approval of new unit owners.
We'll get there.
Oh,
We'll get there. Okay, so board meetings. This is where it gets interesting, because the affairs of the association must be conducted, the business of the association, the decisions must be conducted at properly noticed board meetings, at which a quorum of the board members are present, and they have to be open to all unit owners. So if we have a board of three, two out of the three is a quorum. So if you have two people of the board discussing and making business decisions of the association, that's a quorum that needs to be properly noticed, and it needs to be open to the members. What is the right to be open to the members? You have the right to attend, and the members do have the right to speak with reference to all agenda items. Now, what I recommend is that you don't have someone take over a meeting. I recommend that you adopt reasonable rules and regulations as to how your meetings are conducted, and you adhere to them. Many of my associations will put a little timer. You're allowed to have 2 minutes to address your questions, and then you're not allowed to ask any other questions until everybody else has had an opportunity. Owners are permitted by statute to record or videotape meetings. That does not mean that when I go to your election, you have a right to shove a camera in my face, which is what happens. It's really, really, really intimidating. It makes me nervous to have someone videotaping me all the time. But it does mean that you can make a request to record your meetings either by video or audio tape. You make the request, and you're allowed to put your recording equipment in an area that doesn't cause an interference with the operations of the meeting. Like over there, and I'm being recorded.
Does that include the offspring of an owner to attend the meeting and record?
So I have that happen a lot of the times. Who can attend? A unit owner can designate. Obviously, if you have an attorney on your behalf appearing, or someone with a power of attorney, they're allowed to appear. The offspring, it depends on your meetings, and it depends on the nature of your community. Some associations don't permit tenants to attend meetings. I sometimes tell my associations, why not? You have a tenant who wants to be involved in your community. You may, invite them. Maybe they'll be more helpful to your community. So that's on a case-by-case basis. There's nothing in the statute that says that an offspring can't attend.
And it also depends whether they're a minor or not.
Correct. Or in that case, maybe they're just the only ones that know how to operate the camera. Okay, so we go back to the quorum, and the problem that we have is associations are businesses, right? I told you that there's all these regulatory, managerial, governmental compliance that you have to do, day-to-day operations, from changing a light bulb to cleaning the pool to fixing and renovations, right? If everything needs to be done at a meeting, and you all are volunteers, and many of you have jobs, how is this possibly done? Well, the law of the land is that if you're conducting a meeting, there has to be a quorum. If you're having any decision-making, you're signing any contracts. Now let's talk about side conversations or research work or workshops that you may be having. If there's a quorum of the board, then technically, yes, you have to have a meeting and you have to notice it. So many times you have two, if you have a board of 5, you have 2 members kind of do the research, and then they report to all the other owners. Under Florida law, you're allowed to discuss things by email, and I say also by text messaging, but you can't face-to-face call each other up on the phone and talk about it, or you can't sit at a bar, the three of you, to have these types of discussions.
You can note an executive session and have legal counsel present or on the phone.
We'll talk about that, because that's not entirely true.
Okay.
That's not entirely true.
If I may,
Wait, don't- All right, so I already explained, notice of all meetings of, yes?
if two board members are also members of a committee that is...
Committees have to also have notice requirements. Meetings of committees must be noticed as well.
Let's say somebody's saying that who is speaking, and the two board members go and have a look at who is speaking.
Again, that goes back to the problem that you are operating a business, so technically, things like that need to be addressed.
Yes.
Okay, so as a rule of thumb, okay, there's obviously some emergency discretion that then needs to be ratified at a later board meeting. But as a rule of thumb, use common sense. You're not going to go in, just two board members sitting at a bar and signing a contract for $22 million. You're not going to go in and make a decision on who to fire your landscaper. Those are things that need to be done at a board meeting. But if you're telling me that you have a pool leak, two board members go to look at the pool leak, you have an arrangement with your management company, usually that management company has a discretion to address emergency repairs, a decision needs to be made, you gotta buy a new pool pump. I don't know that there's a correlation with the leak, but you get what I'm saying, then that can happen. So use common sense, don't go signing contracts unless you're at a properly noticed board meeting.
How about having the vendors
Guys, we're gonna stay here till 5.
Yeah, we're on slide 18 of 66, and we have a lot of really good, fun stuff to cover. So we're gonna try to speed through a lot of this stuff, but let's try to keep, we love answering your questions, we really do, but we don't want you guys to not get the benefit of the other half of the class.
All right, so there are provisions for noticing emergency matters. There are even more provisions for noticing matters in case of a national or a state of emergency that's declared. Typically, this happens if there's a hurricane situation where everybody leaves town, you have to address emergency matters that happen in the condominium. Notices for regular or special assessments or anything that has to do with amending the rules and regulations, amending the condominium documents, you need to have a minimum of at least 14 days notice, and that notice needs to be mailed out to all the unit owners and posted conspicuously on the property. Committee meetings, as I said, also need to be properly noticed. Closed board meetings, that gentleman asked me about closed board meetings. So, there's a misconception that you can just have your attorney present and you can shut everybody else out. No, the role of an attorney in a closed board meeting is very limited. You can only have a closed board meeting with counsel present if you are addressing pending or threatened legal matters. Okay, that's it. The only other time when you can have a closed board meeting is if you're discussing personnel matters, hiring, firing, disciplinary action issues. That's it. Those are the only two times where you can have a closed board meeting.
Personnel matters, and what was the first?
Legal, pending or proposed litigation.
Which could be broad.
It is broad.
Because let's
It
say
is
you have
broad.
a leak, and someone says, hey, you have a leak, and you could possibly be sued because of that leak. We take the position that you can have a closed-door meeting to discuss what to do about that leak to try and avoid that lawsuit.
But you can't be bringing in other day-to-day business activities into that meeting just because the lawyer is there. You can, the protection or the shield is only to what's related to a claim or a pending, a potential claim. Or vacancies.
All right. Yeah. We're going to try and speed some of the stuff up that hopefully there's not too many questions on. Board vacancies. What happens when someone passes away, a director passes away, resigns, in some situations recalled? Well, the remaining board, and it doesn't even have to be a quorum, so if you have 3 board members and 2 resign, the remaining board member can just appoint 2 additional board members to serve out the remaining time of those 2 board members' terms that just resigned or passed away. Alternatively, the remaining directors can say, look, we're going to have a snap election. I don't want to just appoint someone, I want to make this, fair and democratic. So they could just say, look, we're going to have an election now to elect the board members that are going to take over for those two people. They only take over for the remaining time of the people that have resigned. That's the same as condos, that's HOAs. Sometimes in your governing documents, though, it may have different restrictions. It may say the only way you could replace board members is, A, B, and C. The governing documents would override the statute there because the statute says, unless otherwise provided in your bylaws, this is how it works. So this is one of those times where if the governing documents say you can only replace board members through election, you can only replace board members through election. Now, who's eligible to be on the board? Generally, it's all members. Most declarations documents say only members can serve on the board. Some say anyone. Some say members or tenants. But generally, it's only members. Who's ineligible? Well, a person who's been suspended or removed by the DBPR, the Department of Business and Professional Regulations. So let's say you're on the board and you've been holding improper meetings or passing improper budgets and doing things improperly. And some of the members in your community complain to the DBPR. They issue a complaint. The DBPR can look at that and say, you know what, these directors are breaching their fiduciary duty. I'm going to remove them from the board, and they can no longer serve. Maybe they'll say they can't serve for a few years.
In 12 years, I've never actually had that either, but it's there.
Yes, and as a general, what usually happens is if you don't hold proper board meetings or you do things and someone complains, if it's not extremely egregious and it's a first-time offense, the DBPR will likely issue an order that says, hey, you've done these things wrong, don't do it again. If you do it again, then we may take additional action, such as they could even fine, they can even have charges against the board members after they've been warned, or they can remove you from office. Yes?
We did that. That organization in Tallahassee isn't worth the paper it's written. You called them, we begged, we pleaded, we did everything. It took weeks and months to get a response, and that's what we did. We got squawked out.
Feel your pain, yeah.
Feel your pain. $930,000.
Unfortunately, even in the last few years, what we've been told is that they've lost a lot of funding in the DBPR. A lot of funding in government, period. Right, but they have an arbitration division that used to have 10 arbitrators, and I think they're down to 4 or 5. They can't handle all of the stuff that comes in.
We're not defending them.
We're not defending them. I'm just telling you why.
It
helps when you get your attorney involved as far as responses.
We know a lot of the DBPR members, and the fact is, we've had some of these exact issues where people make complaints, and it will take 6-7 months. The person isn't even on the board anymore when they finally get a response back from the DBPR, but that is just how it works. Also, board ineligibility, if you're delinquent, you cannot run for the board. So you can't say, hey, I owe the association $10,000, I'm going to go serve on the board. That's not how that works. If you're delinquent, you're ineligible. If you've committed a felony and you haven't had your rights restored for 5 years, you also cannot be on the board.
All right, so shifting gears to, okay. Unit owner meetings and quorum requirements, unless a lower number is provided in the bylaws, the percentage of voting interest required to constitute a quorum at a meeting of the members is a majority of the voting interests. Generally, your governing documents are going to say what you need for a quorum, and the decisions at a members meeting are also majority voting unless otherwise provided. Oh.
When you say majority, are you specifically talking about the board or
That
the
was
owners present?
that owners meeting. For board decisions, it's majority of the board members after quorum. For members meetings, your documents will specify whether it's majority of the total eligible members, so voting rights may have been suspended. It will specify if it's majority after quorum, if it's majority, it depends on your documents.
There is a specific provision, I would say almost all of your documents, that will say quorum for membership meetings, and that will tell you what it is.
Right, so pretty similar for HOAs. Okay, annual meetings. You have to have an annual meeting every year. Even if you don't have an election, you're required by law to have an annual meeting.
And for condos, there's a very specific process, which if you're in a condo, you should be aware of, the 60-day notice, first notice, second notice, notice of intent to be a candidate, then you're allowed to provide an information sheet with your experience. That needs to be mailed out with the second notice, and then you get on the ballot. There's the outer envelope, inner envelope provision, and that is supposed to ensure the secrecy of the voting. Annual meeting procedure. Quorum, that's important. Okay, so for annual meetings, even though it's a members meeting, and technically you need to have a quorum of the membership in order to hold the annual meeting, for both HOAs and condos, for condos you only need 20% of the members to vote in order to hold the election, regardless of what your quorum requirements say. For HOAs, it's 30%. And it also is, if your documents provide a lesser amount, right, it's less for HOAs. And any challenge to the election, you can only have that within 60 days of the election. And if you're going to do a recall, you can't serve a recall 60 days prior to an election. And that's something to keep in mind, because for up to 60 days in associations, an owner can challenge the election. So don't think you're free and clear if no one says anything at the election meeting. You need to make sure you follow all the proper procedures. Associations, homeowners associations, very different. We're on election season now. We are constantly trying to figure out how these HOAs are supposed to hold their elections, because their documents are so broad and unclear and have contradicting provisions, and the statute says you have to rely on what your governing documents say. A lot of times they don't specify a procedure. It becomes really tricky. Work with your management company and your attorney to establish a procedure. There's maybe a section for HOAs. If it doesn't specify, we recommend amending and specifying it. Electronic voting. Has anyone adopted electronic voting? Okay.
How do you do that? That sounds good.
All right, so electronic voting is something that was actually passed in 2015 for all condos, HOAs, and co-ops, but has just recently taken off, I would say. So the board can adopt electronic voting by passing a resolution, and it has to meet certain requirements pursuant to the statute. A lot of secrecy requirements, record-keeping requirement, ensuring that the person who's allowed to vote is the one who votes, a lot of technicalities. But in order to do that, you have to send a copy of the board meeting notice as well as a resolution to all owners at least 7 days. Is it 7 days? No, I think it's 14? 14 days prior to when you vote on it. So you would have your resolution prepared, you would send out a meeting notice package, and then you hold a meeting and you approve it. You don't even have to have your vendor picked out at that point, because the resolution is going to be broad and it's going to give the board discretion to decide when voting electronically is allowed and when it's not. Remember, even if people opt into electronic voting, which has to be done in writing, you have to provide the option to vote the old school way, right? So you're never going to completely get rid of that, at least not anytime soon. Be careful with your vendors. Our firm, for a while, we were going back and forth. Do we make our own software and provide that to our clients? Do we partner up with someone? And we decided we wanted to stay out of that aspect. We wanted to remain unbiased as to how the election is run. So we did a lot of research on it. We have several vendors, and we have one that we've gone through all the requirements, that we know they comply. They change their website in order to comply with the statutes based on our request. So that's who we recommend. But there's a lot of vendors. Just be careful, because there's a lot of vendors from Texas and from New York. They do union voting electronically, and they think they can use the same software in Florida, but the statute is very specific. So you have to opt in writing, opt out. If you opt into electronic voting, doesn't necessarily mean you opt into electronic notice. Two different things. Electronic notice allows the association to not have to mail the notices to the unit owners, but if you opt into electronic notice, your email address becomes an official record of the association. If you opt into electronic voting, it does not. So that's summary.
Do you want to say something?
Yeah, we can give it to you after. I'll tell you, for the associations that I've seen it happen live, it's amazing, and it's time saving, and it just really reduces a huge hassle.
It allows for a lot of amendments to be passed. It reduces the controversy at the election meeting.
Can you change a one-year hold electronic voting, and for whatever reason, change that to the old way the next election?
whatever you put in your resolution. I mean, it's at the discretion of the board. You put in your resolution that at the discretion of the board, you may have electronic voting. And if you want to send it out to electronic vote, great. If you don't, don't.
But if you're going to use it, there's specific requirements that the notice has to specify that. And there's specific timelines that you have to establish as a board as to when someone has to tell you that they're opting in or opting out. So it's statutory, there's statutory requirements, there's administrative code requirements, but overall, it's definitely worth investing the time and energy to get a good vendor and to get the association set up to do that.
But there's nothing on the statute that says, because that's what we were told, that if you held it electronically,
No,
from there on.
nothing,
No.
nothing. Okay, budget meeting. All right, you as an association, as board members, are required to adopt a yearly budget. The meeting notice and the proposed annual budget has to be mailed out to all unit owners at least 14 days prior to the meeting at which the budget is considered. A lot of you have budget workshops or other meetings prior to that where you're not voting on the budget, you're just working on those items. Those should be noticed, but that's a regular 48-hour budget or committee meeting notice. The big one, the one where you as a board adopt the budget, must be held with at least 14 days advance notice. The budget meeting has to be open to all unit owners, but the board votes on the budget. The unit owners can ask questions and make comments, but ultimately, the only vote that is taking place for the approval of that budget is that of the board members.
Nobody has some questions. Can I make a suggestion? We're going to get through this financial stuff, and then we're going to take a quick 5-minute break, and then we're going to get into some of the really interesting topics. So let's keep going, and then...
Okay, now, your budget, your obligation as a board member is to propose a budget that has fully funded reserves. What are your reserves? I call it your piggy bank. Basically, the statute requires you to maintain a reserve schedule. This is for condos. HOAs is slightly different, but for condos, whoa, this is really small. Sorry about that. So your reserves, this would be for your roof, your pavement, your painting, those types of items, or any items in excess of $10,000. And how do you calculate reserves? Let's say you paint your building, the recommended time period is every 7 to 10 years. Let's use 10 just for fun. It'll cost you $100,000 to paint your entire building. You divide $100,000 by 10, and then every single year you're supposed to put that amount in your piggy. Your obligation as a board is to put that in your budget. Now what happens? Your members, and traditionally many associations do not like reserves because it increases your assessment. So the membership does have the right, pursuant to a vote by a majority of the members, to waive or partially waive reserves. The catch is that if you waive reserves or you partially waive reserves, you're not allocating enough money into that piggy bank for what could happen if a hurricane comes, or ultimately when your building needs that paint job and you don't have money set aside. You're going to have to specially assess your association. Reserves can't be commingled with operating funds. They have to be used specifically for the purpose that they are designated. However, there is an ability to pool reserves. So you have your reserve items and they all get put in one piggy as opposed to separate piggies for you to be able to use as to those specific items only. The HOAs are treated a little bit different. If reserves are established by the board or by the developer, then you have to fund them. Otherwise, HOAs are not necessarily required to have reserves.
I think we should.
In general, with a building, the more valuable market, if it had fully funded reserves as a...
Well, and that's a back and forth. Every building works different. I will tell you, lending institutions do look at reserves when they're lending. So that's a consideration that you want to have. Again, it could be a generational thing. It could be just passage of time. There used to be a fear of having these reserves and how they're going to be utilized. So some people said, oh, just assess me later. It's kind of turned and said more people are interested in having a piggy to prevent a huge assessment down the road.
As a general matter, absolutely, if you have more money in your budget, when someone comes in and says, hey, I want to buy in this condo, let me see the financials, and there's a lot more money in this condominium than there is in this condominium, a smart business person would absolutely choose the one that has more money, that has the reserves.
We're gonna,
Add to the members had to vote.
right, so
Vote on reserve.
the members, so you have a budget meeting and you schedule your membership meeting right after. So the board adopts the budget fully funded. And then if the board wants to provide a membership with the ability to waive reserves, they have a membership meeting thereafter where they get to vote.
But the members have to vote to opt out of funding the reserve.
If it's
Yes,
an option.
right. All right, guys, we're gonna take a quick break. We will be happy to take a few questions, 5 minutes, but just so you guys don't go, we're gonna talk about the fun stuff. Violation enforcement, fines, suspension of rights, approving suspensions, hold on, collection of assessments, foreclosures, tenant rent collection, official records, written inquiry, service animals, ADA, FHA, reasonable accommodations. So stick around, take a quick break, stretch your legs, and we'll be right back.
I did not say that, I said.
I couldn't get into
No, you don't have, get a few more. Get a few more.
I became lucky being down here. That's right. It's here. Where it was. We're gonna do it soon.
No, I'm not getting you, so no.
I want to go home. No, well, you have to learn. He's the driver. You got to
Yeah.
And the way our laws is written, I can help you 75% of the homes that have children. What kind of change the laws say 50% plus one, because most people are the college. Yeah, so that's what we're people So
Don't go in for that case. I don't think they're on.
Well, actually,
Nobody, they all complain, all complain about this and that. I said, what are you doing about it? I said, I picked up that. Somebody
have some really good topics to cover right now. So if everyone can take their seats, and we'll go through this pretty quickly so that we can cover everything, but these issues will be a little bit more interesting. Okay, so
If you can get it done today.
Violation enforcement. All right, so what happens when people have unauthorized tenants or paint their house the wrong color or are causing a nuisance? Well, you have in your governing documents enforcement remedies, as well as Florida Statute 718 and 720. There's different remedies that the association has. And I'll just talk about condos. There's no HOAs here. No, there's one. I'm sorry. I'll briefly touch HOAs then. But for condominiums, you have, pursuant to statute and likely your documents, the ability to sue for injunctive relief or for damages. So injunctive relief would be something like, you're not getting access to the unit. You need access as the association. The association can sue for injunctive relief to gain access to that unit. The judge would say, pursuant to the statute, they have access, they've proven they need access. Here is an order, we're going to have a sheriff come and make sure that the association has access to that unit. Okay? This works both ways. The unit owner can sue the association. If the association is not doing proper things, is not conducting itself the way it's supposed to, then the unit owner can sue the association to force them to repair common elements and do certain things. They can also sue for damages. And what's super important about this is in the condominium statute, HOA statute, and almost certainly your governing documents, there's a prevailing party attorney's fees provision. So you may say, wait, is it really worth it to sue to remove someone's dog? Well, if you do, remember, and you prevail, you get your attorney's fees paid for by the other party, assuming that they're collectible. And that's a very good deterrent to people to not want to engage in litigation. So we generally recommend to, hey, let's send a letter. Let's threaten that they're going to get a lawsuit and they're going to have to pay all the attorney's fees if they don't remove their unauthorized tenant, if they don't remove their unauthorized animal, their unauthorized pet. So you don't want to go the litigation route, you don't want to file a lawsuit, you want to do something else, you can impose fines. This is where the HOAs have a stronger statute than the condos. For condominiums, you can impose fines up to $1,000. It can only each fine can only be up to $100, but after the proper procedure is done, where you give them the notice that a fine is being imposed, you give them a 14-day notice that they're going to have a meeting in front of a committee of 3 members to either agree or disapprove of the fine, then the fine goes in place. It can be $100, and for a continuing violation, it's $100 per day up to $1,000 for condoms.
Sorry to interrupt. Just to be clear, the statute was amended a few years ago to clarify that the board imposes the fine. So there has to be a board meeting, and this is where a lot of associations haven't caught on to this. The board needs to impose the fine, and whether you give your management the authority to do that is a little controversial, but the board levies a fine, and then you have to give notice of a committee meeting in order to agree or disagree with the fine. And only at that point is the fine technically imposed.
That's if the committee says, you know what, I just heard from the unit owner, we don't think that the board should have imposed this fine, and that fine doesn't go into effect. So the committee also has to, ratify your fine. For HOAs, if you have something in your documents that say you can impose fines up to as much as you want, and if the fine goes over $1,000, that fine is lienable. For condominiums, you cannot lien on a fine. For that reason, generally, fines don't work as well in condominium settings. Going directly to litigation to make someone do something with their unit to comply with the laws is generally the most effective way for condominiums. For HOAs, we recommend going through the fining procedure, assuming that your documents permit you to fine for over $1,000 and to lien.
And then the other thing is, when we say litigation, and we don't talk about this in a lot of detail here, but pursuant to the condo statute, certain disputes need to go to arbitration, and that's the DBPR. So you may need to to go to arbitration before you even get to a court, and when you do, it's trial de novo, so you have to start over. But there are some things that the DBPR has jurisdiction, and before you even file for an injunction, you may have to consider going to arbitration.
So, you have the litigation or arbitration, you have the imposition of fines, and finally, you can suspend rights. You can suspend use rights, you can suspend voting rights. It has to be in your governing documents. But if someone is not abiding by the rules or is delinquent in their monetary obligations to the association, then the condominium, the HOA, can impose suspension of rights. They can say, you no longer can enter the community on the resident side. We will deactivate your bar card, and you have to go through the visitor side. If someone's delinquent, then this has to happen at a properly noticed board meeting, and it also has to be sent to the unit owner, letting them know that the suspension of use rights or voting rights was implemented.
However, there's a couple of things that you want to keep in mind. A suspension of use rights has a limited scope and a limited reach. You can't suspend the right of someone to access your condominium property. You can't suspend the right to utilities. You can't shut their power off. You can't shut their internet off, okay? Another important thing, it has limited scope. If you are an open community where anyone has access to the
Can you hush, please?
then
Because you have a loud voice and you're carrying, and we're trying to hear them, so.
okay. If you have an open community where accessing the pool is just easy for everybody, it's not controlled, it's not one of these more closed resort style communities where you have someone check you in and out of the spa, suspension of use rights may not be that feasible for you. So you want to really consider whether it's something for your community to implement or not, or it might be useless.
I mean, for the main part, these are what your remedies are if people are committing violations. But generally, as Carolina just said, a lot of the suspension of some use rights don't work in most communities. Suspension of voting rights, the people that are getting their voting rights suspended, a lot of times wouldn't vote anyway. But for suspending voting rights, if for condominiums, if the person owes more than $1,000 or is more than 90 days delinquent, then the voting rights can be suspended.
All right, cool. Yes.
If that unit is rented out, are you allowed to, they use the
You can suspend the
facility,
tenant's use
suspend
rights.
the tenant?
Yes.
Yes.
Assuming that you have that type of condominium where it would be feasible.
We have a tenant that had a condo, and a car that's being used as a storage, storage, stuff.
Oh, what, a car?
They have a car in the parking lot, so they're using it somewhere, that is covered, and use it as a storage, because there are a bunch of
Your
orders.
governing documents may have restrictions, and then you can enforce it in all the various ways that we just went over. So you have to see what your documents say, what rights were given in your document language, and then move forward.
Okay, so as Greg earlier mentioned, collection of assessments. We all know assessments are some kind of like death and taxes. They're guaranteed. You have to pay them. Unit owner, regardless of how they acquire the title, is liable for all of the rents and assessments that come due while he or she is the unit owner, regardless of whether or not they're in possession of the unit, whether they use the common elements, so on and so forth. Unit owners are jointly and severally liable with the prior unit owner. So if you transfer your unit to your spouse to try to avoid paying assessments, doesn't fly. You're still on the hook for assessments. You can't avoid paying your assessments or liability for your assessments if you don't use the pool or the amenities. The rents and assessments bear interest at the rate that's provided in the governing documents, or up to 18%, or whatever the legal rate at the time is. So you want to make sure that you check your governing documents. There's also a difference. If your governing documents provide, you do have the right to charge a late fee, or quote-unquote administrative fee, and the fee cannot exceed $25 or 5% of each installment. And that's a very tricky, because a lot of people feel that they can just start charging late fees left and right, but if your governing documents don't provide it, you're gonna get dinged for it. There's an order of application for payment, first to interest, then to late fees, then to costs and attorney's fees, and then to delinquent assessments. And that's very important. I know when we have accounts in collections, we have a lot of inquiries. And why isn't my balance going down? Well, you know, you stop paying, you have all this interest. They got sent to your attorney's fees. They get paid first, and that's how it works. Lien and foreclosure. So the association has a lien on each unit or parcel for unpaid assessments, interest, and late fees. Attorney's fees are also secured by the lien. The lien process is very, very specific. So we certainly encourage you, if not beg you, to make sure that you retain appropriate counsel in connection with your collection efforts. And that goes beyond having your manager send delinquency notice, particularly because you have issues of fair debt collection that are applicable to condominium associations and homeowners associations. So you need to be really careful with how you go about collecting delinquent assessments. The lien cannot be filed until 30 days for condos, 45 days for HOAs, after you send an initial intent to lien letter. Thereafter, the lien, there are specific. The lien is a statutory form that you have to follow. It has to identify the unit or parcel, the name and address of the unit owner, the address of the association, the amounts due, and the due dates. It's very specific. Another key issue is who signs the lien. I just finished litigating this issue. You need to look at your governing documents and make sure that the appropriate person is authorized. Sometimes your attorney signs the liens. You want to have a board resolution authorizing your attorney to sign the liens. If your manager signs the liens, you want to have a board resolution that authorizes that, but you have to look at your governing documents to make sure and see who your governing documents designates as the person who can sign liens. The lien is effective for 1 year from the date of recording, and that means that you have to file your foreclosure lawsuit within that 1 year time period. Tenant rent collection. So this is a really great statute that came up as a result of the financial collapse. And what we were experiencing was many unit owners who stopped paying their mortgages, stopped paying their assessments, but they rented out their unit and they would pocket the cash from their tenants. And we had associations that were nearing financial collapse. So the legislator, and I'll talk about how this isn't so great after all, but the legislature came in with a remedy, and this remedy is that pursuant to Florida statute, an association has the right to make a demand upon the tenant to collect rent, their rental payment directly. You have to go through a procedure of notification to the unit owner, to the tenant, and once you do that, if that tenant doesn't pay, the association does have the right to initiate an eviction proceeding. That being said, there are concerns with fair debt collection. Our firm has a policy that we do not issue a tenant collection demand unless we previously issued a initial demand letter to that unit owner with the fair debt collection disclosures as appropriate. So you do want to be very careful. I know a lot of associations try to kind of do that in-house. I don't recommend it. I recommend that you consult with your attorneys and follow all the appropriate procedures. Just because an association has the right to collect the rent does not turn you into a landlord. Okay? You're not responsible for fixing their air conditioning. You're not responsible for coming in and changing their light bulbs. However, I must say that I've had situations where withholding of rents comes into play if it would naturally come into play. But that's a whole other area. Yes, sir?
Can condo owners operate Airbnb from their property?
Depends. Depends what your condominium documents say, depends what your local city ordinances say as to, and what your property is zoned for. Some associations have restrictions on the number of days or the time period where you can rent your unit. Some don't, most do. So it's all determinative on your governing documents and what restrictions on leasing there are, we'll talk about in a minute, and what your local the zoning is for.
Okay.
before I get into official records, I just remember something that I didn't say about fiduciary duty. And this is really important because if you guys walk out of here with, and you learn anything from all the information we're throwing at you today, it's that fiduciary duty comes into play. You guys are volunteers, right? So you're not attorneys, you're not professionals, you're not contractors, but you have a responsibility to act in the best interest of the association. So how do you do that? You utilize the professionals. You call your attorney, you call your management company, you call your accountant, and you get opinions from them. And that protects you because one of the defenses to fiduciary duty is the business judgment rule. As long as you guys, as board members, utilize your business judgment to act in the best interest of the association, then you're relatively protected from a breach of fiduciary duty claim. But you need to use your professionals. So don't think that just because you've done it before, the statute changes, the professionals are there to help you. And I know that we get this a lot of time, well, we don't want to incur attorney's fees. Well, we don't want to have that as part of our management contract because they're charging too much for that service, etc. So,
Now or pay later.
right. I mean, ultimately, utilize your professionals because it's a lot more cost effective. If you get sued, it's going to cost you a lot more money. You're going to have insurance come in, your premiums are going to go up. It just gets really messy. Come to us before the issues arise. Okay, official records. Every association has an obligation to maintain official records. Now, each statute, co-op, condo, and HOA, list everything that is deemed an official records. You see the list here. It's a lot of stuff. And then there's this catch-all provision that says, and everything else that's maintained as part of the day-to-day operations of the association. So there's this catch-all. It used to be that you only had to keep everything for 7 years. Now the statute says that some things have to be maintained forever, such as minutes and notices. Okay, so, hold on. Okay, so official records, bids are considered official records, and a lot of these official records now need to be posted on a website. If you're a condominium with over 150 units, you should have a website. The law was amended a few years ago. The deadline was extended as of January 1st of 2019. If you have more than 150 units, you need to have a website. There's a lot of statutory restrictions as to that website, access to the website, and what is posted on the website. So official records are open to inspection by the association member or authorized representative. The right to inspect involves the right to make copies or the right to, at the owner's expense, so up to 25 cents per copy, or you can take your camera or a portable scanner and take pictures. The association can adopt reasonable rules and regulations, and that really comes into play if you have the constant inspector or the constant record inspector, that owner that every week has a new request. So the association can be reasonable, but be careful with what you think is reasonable because there's a lot of arbitration decisions as what's deemed reasonable as far as a restriction goes.
I haven't won once on an association who's made reasonable restrictions. The division tends to side with the unit owner because it's open, sunshine type laws. They are entitled to see everything they need to see as far as the association records. So keep that in mind.
Right. But we do recommend that you pass reasonable rules and regulations regarding the procedures as to what an owner needs to do in order to inspect the records. The association then has 10 business days to provide you access to those records. If they fail to do so, they can incur a $500 penalty. $500 is no big deal, but when you have the owner file an arbitration case and now you've incurred $7,000 in attorney's fees and the owner prevails and now you have to pay the owner's attorney's fees plus the $500, it's a big deal. So make sure that your management company and that your board is aware that if you get anything in writing via email counts for official records requests, you need to address it right away. There are certain records that are protected by attorney-client privilege or personnel matters, specifically social security numbers. The statute makes exceptions for records that are not deemed official records. Medical records of unit owners, if you put your social security or any personal information during the application process for emergency situations, that's protected. Next. No.
She just keeps touching it when I have the remote.
No. Next. Okay.
Right. Oh, we didn't talk about Okay, so real quick, one thing that a condo
does have the authority to do, or that condo owners do have, and homeowner association, it doesn't exist, is aside from inspection of association records, a unit owner in a condominium can provide a written inquiry to the association. The written inquiry could be, hey, association, why is that bathroom closed? And why are you not allowing access to it? Why did you decide to go with this company rather than this company? And that inquiry needs to be sent via certified mail to the association. Once received, the association has 30 days to provide a substantive response, or it can refer it to its attorney, at which point it has 60 days, or depending on the inquiry, it can request an opinion from the DBPR, and then it depends on when they respond.
Which, to your thing.
Right of access to units, I believe we already touched on that throughout the few numerous things we talked about before, but as we said, the association has the irrevocable right of access to all units if it's reasonable in order to maintain, replace, repair the common elements of the association. This generally takes place when there's mold in a unit, when there's a broken pipe, and if there's issues, you go to court, you get an injunction to be able to access that unit, and a lot of times we have orders that don't let the association in. There's mold, it smells, and we have to get police to come out, to bring the order out, to let us come in, to repair the entire unit, and then charge it back to the unit owner. Financial reporting requirements. This is for condos and HOAs and co-ops, I believe. The legislature basically says that if you have under a budget or revenues of under $150,000, every year you're required to report all your cash receipts and expenditures. If you have revenues between $150,000 and $300,000, you have to have compiled financial statements. If you have $300,000 to $500,000, you are required to have reviewed financial statements from accounting. And if you have over $500,000 of revenues, then you're required to have audited financial statements. This has to be done within 90 days after the budget each year.
Right, here's the good stuff now.
Yeah, here's the fun stuff. Reasonable accommodations and reasonable modifications. Has anyone incurred issues with emotional support animals? Anyone have someone request a modification to the common elements? Ramp, pool lift, parking. Okay, so we deal with this daily. This is, I have a whole CE class for managers just on this issue because it's so prevalent and there's so much risk and liability associated with it, simply because it's so easy for a unit owner that doesn't get what they want to file a complaint against the association for discrimination, and the entities in the county that usually handle these tend to be very biased, and I hate saying that, but they're very pro-unit owner. So, what is a reasonable accommodation? A reasonable accommodation is, in the instance of pets, you have a no pet rule, and someone says, I have a disability, the disability impairs a major life function, and I need to have a pet in order to ameliorate the effects of the disability. So they request an accommodation to your rules and regulations. Now, that seems pretty simple, but there's a lot of gray areas in the law. So, examples of reasonable accommodations would be parking spaces, would be animals, would be, well, that's reasonable modification, sorry. So, if you are disabled, and you have to have someone provide a written letter, let's say, that says they suffer from a disability. You don't get to ask what their disability is. Having a professional attest to their disability is enough. Now, you're not going to have a podiatrist talking about a mental health issue. That can be questionable. But the association has a right to do a meaningful review. These are all terms from case law. Meaningful review to determine. If they wait too long or they don't provide a response, that's deemed a constructive denial. And that can get you in a lot of trouble. So we recommend that associations adopt procedures or guidelines, because you can't impose any additional rules on anyone with disabilities. So guidelines in order for the procedure to request and adopt a reasonable accommodation. Now, we've had issues where people request reasonable modifications. Reasonable modifications is a change to the common elements. The difference between a reasonable accommodation and a reasonable modification is an accommodation is to the rules and regulations. A modification would be to the common elements, to the door width, to ramps, etc. Now, while the association can go through the same review and has to comply if the individual has a need in the accommodation, there's a nexus between the need and the accommodation, the unit owner generally is the one that pays for the reasonable modification. Reasonable accommodation, the association has to incur the costs. Now, there are exceptions. It has to be feasible. It can't change the nature of the condominium. So, for instance, someone has a disability and requests an accommodation for the association to have the maintenance guy take out their garbage every day. Okay, well, the association may have to comply. However, their maintenance guy only comes twice a week. So for them to bring a maintenance guy on property the other days in order to take out the garbage is an inconvenience. It's going to cost money, and it's a burden. And so the association may have the right to say no. This is a very touchy issue when it comes to accommodations or reasonable accommodations. There's a lot of fraud in this area of the law. A lot of people are taking advantage of the reasonable accommodation requests for emotional support animals. Now, there's terms that are misused. So, for instance, an emotional support animal is defined under the Fair Housing Act. A service animal is defined under the ADA. I remember there was a question as to whether or not condos fall under the ADA. That depends. If you have any services that are open to the public, if you have a restaurant that's open to the public, or if you have other amenities that are open to the public, then all of a sudden your entire condominium property falls under the ADA. And so now you have to comply with both the ADA and the FHA when it comes to these type of issues. Generally, when someone says I have a service animal is defined under the ADA as a dog or a miniature horse, and I always say once I get a miniature horse I can retire, or a miniature horse that is trained for a specific purpose to help an individual with a disability. So you can have a service animal that's trained to alert you when your blood pressure is going down, alert you before a migraine comes on, or a seeing eye dog. Those are all service animals. And those are generally relatively obvious. The emotional support animal is where you kind of have a basis to ask more inquiries and do a meaningful review. But you have to be very careful. You can't ask for medical history. You can't ask for details. And the issue that we've been incurring a lot is those letters from the websites. So about a year ago, I got 2 letters, exactly the same letterhead, exactly the same language, signed by 2 different therapists from different parts of the country, and for different associations. So I'm looking at this and I'm like, this is weird. That's kind of creepy. And one of them left this certipet.com on the bottom. So, of course, being curious about this and talking about this all the time, I went on certipet.com. Certipet.com makes you take a survey. Are you sad? Do you sleep at night? Do you have any anxiety? It doesn't matter how you answer them. At the end, it pops up and it says, congratulations, you qualify to have an emotional support animal. Pay us $200, we'll set you up with a therapist that's going to write you that letter. Now, there was a statute that was a bill that was introduced in the legislation last legislative session that tried to make it more difficult for associations to be able, or for owners. It pretty much banned those online letters, made it so that you had to have a relationship with a therapist, and included a few other requirements, but it didn't pass. Hopefully it will. We've been hearing that HUD is imposing new guidelines anytime soon. There's been, what was it, like a letter?
Dr. Ben Carson, and I'm going to sound
Secretary of
yes, thank you, Secretary of HUD. There was an opinion issued or a letter issued early last month about the concern that these teletherapy service animal BS websites are actually essentially defrauding consumers because of it's a fraud upon consumers. So they look like they're taking this avenue. Again, my personal opinion is this isn't going to be fought in the condominium front. It's going to be fought in the airline front, which has a similar statute. But there is some movement towards that.
So the one thing to remember is if the request is not obvious and the need for the request is not obvious, then you can inquire a little bit more. Be careful with what you ask. I have some associations that every time they have a request, they send it to me to review. Because They're using their business judgment. They don't want to be on the hook if they get sued, so they rather have an attorney put it in writing as to what they should do. When it comes to emotional support animals, we generally operate under the 1/3 rule. 1/3 of them are legitimate. You should approve it. 1/3 of them are clearly bogus, and usually the ones that get really defensive and angry and start throwing the law at you, those raise a little bit of concern. And then there's 1/3 of them that are probably fraudulent, but you sent another letter, you followed up, you requested more information, and they provided everything. So in writing, you have everything. Now, you need to think about protecting the association. You should keep those records in a sealed envelope as part of your official records of the association, because if you're a no-pet condominium and there's an owner that has allergies and now doesn't understand why there's dogs everywhere, you have to be able to show that you did your due diligence, you as the association requested the opinion of an attorney, and you've dealt with it, and you've researched it, and you requested the information you're allowed to by law, and you had to grant the accommodation.
If your rules and regulations establish that all animals must thrive in the service elevator,
You cannot enforce that for service or emotional support animals. It's deemed an additional restriction, and HUD takes a very strong position on it. Now, there's the issue of, well, does the emotional support animal get to go on the pool deck with the individual? And, you have to address these on a case-by-case basis. You can't have general. It needs to be addressed individually because it depends on the disability, the need, and the accommodation that they're requesting. If they say, I only need an emotional support animal because I suffer from anxiety and I need help sleeping at night, that doesn't necessarily justify having the dog with them at the pool, does it? Are you sleeping at the pool? So there's little ways that you can go around it, but it's really tricky because it's so easy for someone to sue the association over it.
What about just out of curiosity, what about the rights of the owner with the allergies?
Right,
so have you run up against that? Because
Yes.
one set has rights,
Yes.
another set has to have rights.
An allergy or a disease of some sort, that's also considered a disability, and you have to accommodate. So a lot of times associations are like, well, what do? I can't tell this individual to go here, and I can't tell this individual he can't ride the elevator because we don't know where this individual is which elevator they're gonna take. So what we recommend is you sit in a room with everybody and you work it out. I mean, you go back to the old school way of making things work, face to face, you guys are neighbors, you need the dog, you have allergies. Although a fear of animals is not deemed a disability, and I get that a lot. Well, I'm terrified of dogs. That doesn't really fall into the category where it's a competing disability.
This is diagnosed by a professional.
Right.
Can a situation check the doctor who issued the letter?
You cannot contact them. You can go online, and there's actually lists of these doctors that we came across recently, and there's a lot of papers that are written that analyze this. So yes, go online, Google it, make sure that they're legitimate, they have a license, they do what they say they do, make sure the letter is dated and signed. You do your due diligence, but you can't call the doctor, you shouldn't request more information.
We look up all the doctors when we get the letters. We look up the doctor immediately. If the doctor is not a licensed doctor anymore, which is happening, we say, look, this doctor doesn't have a license to practice. We're sorry, we're not accepting your letter.
It doesn't have to be an MD, because it could also be a mental health counselor.
Social worker.
It has to be somebody who is like
qualified to attest to the disability. And it's very broad. The common issues with breed, there was a federal case in Miami, I don't know if you guys are aware of, where someone came and said, I have a Rottweiler, he's my emotional support animal, and the association goes, oh, Rottweilers aren't allowed in Miami-Dade County. I'm sorry, not Rottweilers, pit bulls, sorry. So, I have a pit bull, pit bulls are not allowed, so the association said, we can't grant that reasonable accommodation because you're going to be in violation of county ordinances. And it went to federal court, and the judge pretty much ruled that federal law trumps local law. Doesn't matter what local law says. An emotional support animal can be anything. We joke that she's had this one's had an emotional support human.
Yes.
A request for an emotional support human.
And the reason that came about is someone wanted to circumvent the tenant, the leasing and occupancy restrictions, so he had an emotional support human.
So, remember, there's also requests for multiple animals. We always...
It's called codependency.
We get requests where, well, I have 2 animals, but they're best friends. They've been with each other their whole life. This animal needs this one to survive, but dog Fluffy doesn't need, I'm not good with these names off the top of my head, you're good.
Fifi and Fluffy.
Fifi doesn't get the right to have a reasonable accommodation for Fluffy. If you need Fifi, and she's the one that provides a reasonable accommodation, then Fifi doesn't have the right to have Fluffy with her.
Except
If Fluffy provides some kind of service, or there's a nexus for the need for Fluffy. Sorry, Fifi and Fluffy, you messed me up.
sorry. So basically there's you can have a regular pet and an emotional support pet. So for condominiums that only allow 1 dog, you have Fluffy, my dog, and Fifi, my emotional support. Or she had a situation with Silky chickens.
Oh, that one was a good one. So, good example. So this was an HOA, and the owner requested, she had these like silky chickens. I don't know if you guys know what they look like. They're actually really cute, and people dress them up, and they're adorable. So we had a request to keep a silky chicken, and this owner got the letter, said everything. She suffered from fibromyalgia, or whatever the case may be, and she benefited from having this chicken around. So we came back and we said, okay, you can have 1, but there's no basis for you to have 3. We went back and forth, and it turns out that these type of chickens are herd animals, and she said that she benefited from seeing the chickens interact with each other, and that assisted her with her disability, and we had to allow it because we had everything in writing that justified it. So again, case-by-case basis, use the assistance of your management company and your attorneys when evaluating this.
So the service animal has a doctor's letter, does the support animal have?
Both need someone need for both.
If someone's blind, you're not asking them for anything.
Right.
No, but okay, so what we have is, we have people that come in and they say, this is my service animal.
They misuse the terms, and I'm sorry, I try to clarify that, yeah.
And they can't, say, okay, we'll have an interview. The dog comes in, the dog sits next to the person, calm, quiet, isn't aggressive. The other dog comes in and it's like, and everything. It's not a certified.
So there's no organization that certifies service animals or emotional support animals. None. All those, like U.S. Registry, all those that you see, those certificates, anyone can go online and pay $50 for
Any
it.
association that's requiring a certificate
Don't know.
doesn't exist.
Yeah.
Does not
You
exist.
can't, like, there's certain companies.
No. Okay, so a service animal, if I want to train my own service animal to help me, there is no requirement that that service animal be specifically trained by someone certified to do so. So service animals and emotional support animals, no official government entity that registered them. These are all private companies that are fooling you guys and making you buy these certificates. You can't impose requirements that someone have a vest on the dog or a specific collar. You can't impose different requirements as to what elevator they're going to take. You can't make them carry their dog. You have to allow it even if you have a 20-pound limit on the dog and someone has a 100-pound dog, you have to allow it. But you can do your due diligence. Now, as interview, and I think you were the one who asked about it. So we represent a very large association, multi-million-dollar in the Keys, and they were having this issue, and they wanted to ban aggressive dogs. But we're trying to explain that banning aggressive dogs is very broad, and how do you determine who is aggressive and who isn't? And do you do an interview? And anyone can bypass all these restrictions by saying it's an emotional support animal. So what is it really doing to assist? But one of the recommendations that we discussed was, if you're so concerned about dogs being aggressive, then have them come to the interview with the individual. Have them get a certificate from a certified animal trainer that says this is not an aggressive animal. But when you do breed restrictions,
You can't do it if it's an emotional support dog.
not if it's an emotional support animal, sorry, but in regards to an interview with a dog. You can have a certificate that says that the dog is not aggressive. Not for an emotional support animal, service animal, cannot impose any additional requirements. The only thing that we normally do is recommend guidelines, which says you need to comply with the county requirements for vaccinations. You have to register your dog so that we know that this is an emotional support animal. If the animal passes away and we get another one, then we need to have all that information. So the association can impose procedural requirements. Don't call them rules, call them guidelines. Make sure that it's clear, make sure that you're not violating any of the statutes when you write them. It's very wishy-washy, but we're hoping that within the next few years, this will be clarified and no longer be the basis of most of my telephone conversations.
Just because someone has the right to have an emotional support animal doesn't allow that person to have that animal pee and poop everywhere. So you are still responsible for your animal. You are still responsible if your animal, it becomes a nuisance, meaning yapping, yap, 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 everywhere. Or if it pees, poops, chews, attacks somebody. If you have that problem and the person has an emotional support animal, before you come to me, I want to see a file this thick, okay, a documentation of it occurring, so that I have the means by which to enforce this and say, we get it, it's an emotional support animal, but it's a nuisance, so it needs to leave.
And the other issue is, well, it's an emotional support animal. She says she needs it for social interactions, but the dog's left out on the balcony barking all day long. Well, clearly, it's not really providing the emotional support. So at that point, you allow them in, and then if it's a nuisance and it doesn't fit with the need, then you challenge it on that basis.
It's different than the documents, that's what we have. If it's a nuisance, then we have a right to have.
Right, but be careful.
I
do not.
Many dogs that have done this. That we've approved the emotional support animal. The dog is left out all day barking. We go to the DBPR.
Yeah.
The DBPR. All right, as long as you have the proof,
Yeah.
you have the audio, you have whatever. We're requiring that this dog be removed.
When owners complain, tell them to send an email.
Why should they be with them 24/7?
Well, that's
It's not required.
It's not required because-
Support animals to be just for sleep. I
Right.
need someone to sleep at night. I need someone to be with me when I'm home alone.
Yeah, I suffer from post-traumatic stress syndrome, and this triggers me, so every time I do this, I need the animal there. So,
Can you require a new letter?
no.
What about the health proof of vaccination?
That's really compliance with county ordinances.
Yeah, I mean, we put it in our guidelines when we assist associations with it, but listen, if they don't provide it, I'm not gonna recommend that you pursue it.
All right, Kaufman language. You all are doing a great civic duty by being volunteers, and this is kind of something that's very near and dear to my heart. We're going as quickly as we can. Kaufman language. What this means is the application of the pertinent version of the Florida statutes to your condominium documents. So there is a provision in most, if not all, of your, should be, in your governing documents that talks about the act. And it defines the act as the Florida Condominium Act, Chapter 718. And here's the buzzwords. It's either going to just say, as the date that this declaration was recorded, or, which what we call Kaufman language is, as it is amended from time to time. Why is this important? This determines what rights and abilities you have in your condominium documents. For example, I talked about tenant collections earlier. If your documents do not have Kaufman language and do not provide for tenant collections, there's a chance that somebody could challenge your right to do a tenant collection. Another big one. Many of you have some older condominiums, okay, that were enacted prior to 2007. At that time, if a unit goes into foreclosure and the bank takes title to the unit, the old documents, I know you guys had it, the old documents will say that when the bank takes title to that unit, that debt to the association is completely wiped out. The statute has a safe harbor provision, which says that right now, as of right now, the association's entitled to 12 months or 1%, whichever is less. But if you don't have Kaufman language, that debt is wiped out. Or if your governing documents say 6 months or 1%, you're stuck to the 6 months. You don't get 12 months benefit of safe harbor. So there's a lot of things. So here's my beef and maybe what you guys can do to contact your local legislative representatives. You have a condominium crisis. You have the financial collapse of 2007. Now, there were a lot of statutory enactments that were put in place directly to try to give you guys some aid to help struggling associations, okay? Now we're being told that because your association, your declaration is a contract, if it doesn't have Kaufman language, then those mechanisms that were provided to you by your legislature because your condominium is a creature of statute, I know I'm getting very theoretical here, are not available to you. What is the point to having the legislator enact a statute if some of you can't benefit that? It doesn't benefit new associations, it benefits associations that are established that were in the middle of the financial crisis and they were crippled by the economy. So all I'm saying is that this is something that really needs to be addressed. It's a huge problem for us, and at the very moment, every single time one of you guys calls us for an opinion, the first thing that we have to do is determine whether or not you guys have Kaufman language in your declaration. And it's really a problem. I'd be happy to talk to you guys more about it another day because I can keep going. But please keep this in mind that your legislature is putting in things in place to try to help you, but you may not be able to avail yourself of that help.
Can you change that? Can you change your governing documents?
Yeah, but you have to amend your declaration.
That's what I mean.
And it requires a vote of the unit owners.
Every time someone contacts us and asks us, hey, we want to do an amendment to the rental restriction or something else, we always say, okay, we also suggest that you add in Kaufman language if you don't have it at this time. You tackle all of the amendments at once, and if you're going to do something else, you might as well put Kaufman language in your documents at the same time.
All right, we're going to try to go through this. This is interesting. Authority to approve or disapprove leases. You don't have an inherent right to approve or disapprove a lease. There are very limited rights. First and foremost, your rights must be in your governing documents, not your rules and regulations. It has to be in your declaration whether or not the board has the right to approve or disapprove a lease. Even if you do have the right to approve or disapprove, this right is very limited. Obviously, you cannot disapprove a lease for any discriminatory reason. There are many items in play, such as credit scores, criminal history, things of that nature, that there's a line of thought that your criminal history could be deemed a discriminatory reason because there is a studies show that certain minorities are more prone to have a criminal background than others. Same thing with credit scores. Women traditionally, not now, but traditionally had lower credit or no credit because they were married. Up until, I don't know when, you couldn't even have a credit card as a woman. Things of that nature, you want to take into account whether or not it's really a factor that determines something for you to approve or disapprove. So if you're going to have leasing restrictions and you're going to have the right to approve, you need to have a set of standard factors. This can't be a shaky thing. You have to set up a procedures. Everything needs to be addressed and taken care of in a uniform basis.
Isn't there law as far as the number of people per bedroom?
That's county, but be very careful when you enforce it, because I've had associations that have gotten sued for discrimination because they had a sign that said only 2 people per unit, and the individuals were pregnant and they were going to have a baby and they were trying to purchase the unit, and the association said, no, you're going to have 3. You can't
That's a
purchase
violation
the
of Fair Housing.
And that's a violation of Fair Housing Act. They ended up having to pay a lot of money because those tenants didn't buy there. They went somewhere else, but guess what? They sued.
Now there's some of you may be in 55 and older communities where that's not necessarily, it's a different set of facts for 55 and older, but you do have to take into account those types of issues.
Other than being expecting a child, so someone wants to come in with 3 and 1 bedroom.
I would rely not so much on the older documents when it comes to that. I'd rely on the county ordinances. Sometimes they have a square footage provision. You have to be able to justify it. If you're a condominium and you have a bad plumbing system and having too many people in the unit creates issues, or water bills, but generally you don't want to just point blank.
County, not state.
Should be county,
County,
even city.
even city. They will probably have ordinances.
Keep.
Who is responsible to putting those restrictions for to approve or disapprove? The members?
No. So your governing documents, if your governing documents will have it, it'll be the board has to approve or disapprove.
And the governing documents sometimes will have specific requirements and basis for approving and disapproving. Don't rely on them blankly, because a lot of times those requirements could be discriminatory. But we generally say there's 3 bases to approve or to disapprove. If they lie on the application, make a material misrepresentation. So you should always ask, Have you ever been convicted of a felony, a misdemeanor? Have you filed for bankruptcy? Have you ever been evicted? You can't deny them necessarily on those bases and on those answers, but if you catch them in a lie when you do the background request or the background search, then you can. If they, on the face of the documents, let's say it's a 1-bedroom and they say there's going to be 10 people living there, that I would say right there and then they're in violation of the governing documents, they can't do it. Or if they've lived in the community before, and again, you have a file this big on them because they were horrible tenants and now they want to buy a unit, then you can't.
Or release their unit. You can deny them if they've been a problem the previous year.
Right.
You can say, look, you've had these many violations, you want to release, and if it's in your governing documents that say you can deny leases for this reason, you can say, no, we're going to deny your release.
But when you do all this, you want to make sure that you set up a protocol, a procedure and a protocol for processing sales and lease applications. The other thing you want to keep in mind is, do you really have approval rights or do you have right of first refusal? Many of you who have older communities will find that instead of an approval right, what you have is a right of first refusal. And what that means generally is that if I want to sell my unit, I have to notify the association, and then the association or anyone else in the in the condominium has the right to bring a substitute buyer under the same terms and conditions. If you can't procure that, that person, my proposed sale goes through. I don't have the right to deny. It's a right of first refusal. So you really want to make sure that your governing documents give you a sales approval and not a right of first refusal.
And if you do have a right of first refusal, we've been amending a lot of those out because it becomes really problematic. The association shouldn't be in the business of buying units, of offering the unit for sale to all the unit owners. It's just complicated, it's messy, it leads to litigation. Don't do it.
All right, I briefly covered this, credit score. I have a lot of associations who say that your credit score can be linked to what kind of tenant you're going to be. That's really, I mean, it's a hot topic, it's debatable. My personal opinion is your tenant's credit score has no basis whatsoever as to what kind of tenant they're going to be. Plus, what do you care about their tenant, about their credit score? They're not the ones that are making payments to you as the association. The unit owner is ultimately responsible for making payments to the association. Same thing about criminal history. I made a comment earlier that you want to be very careful. I have a lot of associations who send me credit history reports, and I have a marijuana possession charge 10 years ago. Really, how is that going to be effect on whether or not you should be approved or not? I have speeding violation. Okay, so if you have a battery charge, charge, not conviction. Remember, innocent until proven guilty. If you're guilty of a battery charge and you served your time, everything needs to be accounted for on a case-by-case basis.
And the one thing about criminal history is that HUD issued guidelines a few years ago that said that if you're going to deny based on criminal history, you can't deny just based on arrests. It has to be a conviction. And it's specified that the association has to have a policy that is justified, reasonable, and it serves a purpose. And the burden is on the association to prove that. So again, it opens you up to so much liability. You're better off having a very specific, detailed application and denying them because they lie.
And these past things, the emotional support animals, the denying of animals, the denying of tenants, the denying of sales, these are the ways that your association can get in trouble. These are the ways that, as a director, if you knowingly are denying people that should be approved, can get you in trouble. So make sure you do consult before you deny people, especially if they come back and say, hey, I have an attorney. They say I can't, you're not allowed to deny me. Yes?
We have a policy that new renters can't have pets.
Where is that policy?
Wait, a policy as a rule and regulation, or did he put it in the declaration?
I don't know, but I can find that out. But what happened is that the board decides the declarations or the unit owners.
The declaration is made by your developer. The developer says this is the declaration, and if it's amended, that's the unit owner.
Well, the board decides what amendments to submit to the owners for a vote. So generally, the board needs to be in agreement with those amendments. Then the attorney drafts it. Then you send it to the ownership, to the unit owners, and then they vote. It depends
no, it depends on your document.
It's 75 in our account.
Okay, that's
But yeah, so we have a thing that owners can have pets, renters can't unless there's a grandfather in.
So generally,
Or these are the
that,
And I
Most
think
of
it's,
us
I
are not-
think it's just,
so you're not, the general rule is you can't discriminate between owners and tenants, and it depends on language that you have in your documents, but there is a really old arbitration case that allowed that. I just don't know that it would be upheld if contested.
And either way, you're gonna submit an emotional support application for that animal and game over right now.
Exactly.
Isn't it the fact that a renter has the same rights as an owner? Because an
Not all
owner
the same
cannot-
rights.
An owner cannot give any additional rights to the renter.
It's not all the same rights, but they have the right of use, the right to access the unit, etc., but they don't have the right to vote. So it's not everything.
Rental restrictions, which kind of go on the leasing and approval rights. If your association documents don't say anything about rental restrictions, then, hey, Airbnbs or any type of rental restrictions, you cannot impose. These need to be in your documents unless it's a county restriction. Miami-Dade County says, hey, there's no short-term rentals, defining short-term rentals as rentals for 30 days or less, then you can enforce that because the governing documents say you can't violate a county or state law. However, if you want to impose rental restrictions, then you need to amend your docs. And for condominiums, if you are going to make strict rental restrictions, such as there could be no rentals for the first 2 years of ownership. This is a great one to get rid of investors purchasing up units. You pass an amendment and say you can only rent for 1 year and you have to own the unit for at least 2 years before you can rent it.
But you can't say you have to live there. Be careful.
And this only applies for condominiums, not HOAs. If this passes as an amendment, this only applies to the unit owners that have consented to the amendment and future owners. So if you have current investors, you're not going to kick them out or prevent them from renting if they don't approve it. We do generally suggest that you pass amendments that say, hey, 1 year, especially if you have renter problems, you can only do a minimum rental of 1 year. You can only rent one time within a year, because a lot of people will get away with this by saying, oh, they broke the lease, I'm going to re-rent it again. There's a lot of tricky Airbnb issues. That's a very, very difficult thing to catch the people doing Airbnbs. You got to be very vigilant. But yeah, we absolutely recommend that if you want to prevent your community from becoming a rental community, pass an amendment prohibiting people from renting for the first year or two and making it a minimum of 1 year rentals.
And prohibit advertising on Airbnb, because if you can't catch the tenant there, you may be able to still hold them in violation for the fact that they're advertising it to rent on a transient basis.
All right, you guys have been incredibly patient. I know we could probably talk till tomorrow on this, but this is the last topic we'll cover, and it's transfer fees. And this is a hot topic right now because we just have an association that got dinged in a class action for a significant amount of money. What are transfer fees? Some of you guys charge move-in, move-out fees. Some of you guys charge pet fees. I've seen elevator fees. I've seen security deposit fees, but for unit owners, so on and so forth. So the Florida statute only allows you to charge a transfer fee of $100 per applicant, not including husband and wife or with dependent children. Anything else that you're charging for condominiums associations is not permitted. So if you're charging a move-in, move-out fee of $400, which is very common, not permitted. HOAs don't have this limitation. What you can charge is a refundable deposit for move-in, move-outs to secure any damages to the common elements. But you cannot charge more than the $100. Also, it has to be in your governing documents. So if your governing documents say nothing about transfer fees or say an amount less than the $100, guess what? You're stuck with that less amount, or you are not permitted to charge transfer fees. Common transfer fees that I see, as I claimed before, pet fees, move-in, move-out fees, non-refundable damage deposits, none of them are allowed. Okay.
Thank you guys.
We'll take questions. We'll take questions.
Thank you guys. Please make sure that your information is correct on the sign-in sheet, and you guys have all been very patient. We really appreciate it.
Thank you. Let's give them a big round of applause. We spent a lot of time. And we know when we have these programs, this is your opportunity to get what type of legal advice? Free. Free. There you go. So Here's what we have to do. All right, again, I said I would make 2 reminders at the end. One is the evaluation form. Please take a minute, fill those out, and on the way out, Ashley's there, just drop them on the desk, okay? Number 2, you have the thing with Van, our blog. Please take that, just get it, and, sign up for it, and it'll give you a lot of information. Any questions otherwise that you have, the team of attorneys are here. I'm here if you need a property management question or something like that. Remember, here's 2 signs up here. Eisinger, Brown, Lewis, Franco, Chiat, attorneys at law. Attorneys, if you need a good association attorney, please give them a call. Please talk to them about that. And secondly, remember, we're the other people. We actually do property management. Okay, we actually do. So if you have any questions or anything like that, we are the oldest family-owned firm in the entire state of Florida. 3rd generation family. Bill Campbell is there. My card is on the back table, Gary Pyatt. If you have any questions whatsoever, please give me a call. I live 10 minutes away from here in Aventura for the last 30 years. So I'm operating associations and everything right around here in Dayton, Broward. So if you need us, call us, pick up my card, give me a call. If you need a good attorney, speak to these guys. We appreciate it. This room is booked immediately right after us. That's why you see the guys coming in. So I do appreciate any trash that you have. Do us a favor, please, because we're going to need to do it anyway. Just pick it up, drop it in the can to the back. We appreciate it. We'll see you at the next program. Thank you.